Why do you get so triggered by me?
Not triggered. What do you mean?
Every time we're on a panel or something, you just come out swinging.
Okay, because on panels, you also come out swinging, okay? And you're really rude for no reason.
You know what? Maybe I was a little rude.
Here, I'll ask you a question, because I actually am genuinely curious, okay? So, for ground rules, and I think you know this about me, right?
Esports Batman is someone I think has no credibility on this question, based on... sorry to be...
Uh-oh. He was disagreeing. He was fine with you a lot. Uh-oh.
Federal issue.
It's not the way that you think it is.
Because it feels like we literally just said that, like, it could be done on a whim, which doesn't feel any closer.
No, I didn't say that.
Okay.
When people say whim...
Yeah, what does a whim mean?
When people say... Okay.
No.
What's up, man? Hey, why do you get so triggered by me?
Not triggered. What do you mean?
Every time we're on a panel or something, you just come out swinging.
Okay, because on panels, you also come out swinging, okay? And you're really rude for no reason.
You know what? Maybe I was a little rude.
Here, I'll ask you a question, because I actually am genuinely curious, okay? So, for ground rules, and I think you know this about me, right? I think Trump should be disqualified based on my reading of everything. Obviously, it seems whatever line we draw, he's way the f over it. But I agree with Lauren's question, and I do think it's good to ask, like, what does the exact process look like to disqualify somebody for something that they don't have to be charged with? That's a really hard question, I think. And then the logical follow-up.
Not answering that question.
Sure, that's fine. But then just, the logical follow-up that I'm going to ask, and then you can incorporate this into your answer, is like, let's say, somebody comes in and they go, Kamala Harris can't run for office. She bailed out BLM protesters. And part of what they did was like Chaz and trying to attack government officials because they didn't like election results or whatever, right? Yeah. Okay, go ahead,
So before I answer that question,
I
just want to say there was a lot of criticism of how I came on that panel. And I think a lot of people made good points about how I came on. And so that's criticism that I'm taking to heart. And so thank you everybody who like is telling me how to change my approach. I hear you. I'm doing my best to try to incorporate that. It's hard because I think like Steven come at it a particularly combative approach usually when I'm on those panels at least. And it's not the kind of constructive stuff that are you laughing?
Oh no, I agree with you. Yeah, I mean I do it too.
Yeah. Okay. All right. I'm a little debate brain. All right. I'm a little debate brain.
That's good. Right. You literally just got out of law school. You should be, right? That
was years ago, bro.
How many years ago? Like 2 or 3?
That's over 2 years. That's
2
like
years? You're a child, okay? 2 years is yesterday, all right?
I'm a child.
You're getting there. Pretty soon, you're going to be DMing me like, man, Destiny, I felt like it was just yesterday. I was 31, and now I'm already 33. The years are just slipping by. But you're a strapping young lad. You got your whole life in front of you, okay? Yeah. Go ahead.
You're right. You're right. Okay. So to answer your question as directly as possible, and the reason why it sounds like I'm hedging is because and people acknowledge this in the comments, every state can have their own particular procedures for assessing qualifications, whether that is the 14th Amendment or whether that's any other qualification for office. And so you guys want to know, like, what court do you go to? Who's the agency that makes the decision? Is it an agency? Is it a legislature? Is it a judge? And the answer to that is it might be different in every state. And so there's this insistence on, I think on your behalf, which I think is not like malicious, to like find out what is the procedure. And the answer is there are multiple, and the reason why I started my answer being like, everyone needs to follow the Constitution is to kind of, I think it was a bad way of trying to tell you that the truth is multiple different actors on the federal level and at the state level, and it's different between the states, enforce Section 3 of the 14th Amendment in potentially different ways. That's the answer.
Gotcha. Now, can I ask a question on that? So, like, because I don't know all the legal shit, okay? Lauren knows more than that on me, okay? But it seems like, it seems to be that, like, so you can say that, for instance, that, like, every state has its own procedure, but it feels like there are these overarching federal things, or there are these other overarching rules that kind of demands not a uniformity, but, like, there almost seems to be, like, a standard procedure that every state ends up following that I'm not intimately familiar with, but that seems to be the case. Yeah.
So let me tell you sort of, this will likely always get funneled into the court system, into either the state court system or the federal court system. But the reason why it's different approaches to get there is there might not be a state mechanism to assess qualifications on a state agency level. In some states, they allow you to just have a lawsuit without any standing. Standing rules are typically required for the federal courts, but they're not required for state courts. So there are some states, like I'm not sure if this is true of Colorado, but there are some states where there's, I think, quo warranto actions that you let citizens just file lawsuits. And that would be different than like a Secretary of State assessing a particular candidate. Ultimately, it will likely be funneled into the court system, but how it starts and how it gets there and who makes the first initial step might be different in each state.
Okay, sure. But then I guess then the next question would be that, like, because so like how do you get through the Kamala Harris thing? Let's say a bunch of conservative states are like, we're not putting her on the ballot. We don't think that she meets it.
Yeah.
And this is self-executing 14th Amendment, get fucked.
So I just want to I'm going to answer that question.
Yeah.
But the reason why I'm hesitating to answer it just like at the initial level is I want to let you know that that's a separate question than what we've been talking about. That's applying the standard to Kamala Harris. The first question is like, what are the processes to evaluate Section 3 claims? That question, like that has an answer regardless of double standards or how you would apply it. The answer of who gets to apply it should be consistent, right? And so that's why I think there was conflation on the panel between what the process is and whether the standard applies to certain actors. And they're different questions. Can you see that?
The different questions are, so repeat those two things again. One is...
Yeah. Who is assessing the Section 3 question?
And when who is that? So when you say who is assessing, is that a question of forum or is that a question of standing?
Right? Yeah. Is it a Secretary of State? Is it a state court? Is it a legislator?
Okay.
What is the actor that is assessing the Section 3 question? And the separate inquiry is how would we apply it? And what is the correct standard?
Okay.
Does that make sense?
I agree with that.
Who's applying the standard and what the standard is?
Sure. So murder is wrong. So, but the question is well, who has standing to bring murder charges? Yeah. It's the state. But then, like, what is the application? What does criminal procedure look like, or whatever? Sure, those are two separate things. I understand that. Yeah.
So that's why there was some confusion, I think, because those questions were getting conflated a little bit. So I think that the easy questions about the 14th Amendment, they're not really easy, but I think that they're clear answers. Is it self-executing? Did there need to be a law passed? Is it enforceable by secretaries of state without criminal convictions? Those are kind of like the who decides questions. And then the second question is the substantive question of how would you apply it? And
I think I agree. So the first part is the standing part seems to be boring to me, that like a voter could sue, a candidate could sue, the secretary, whatever. That's fine. Yeah. But then the interesting question is, by what grounds do we disqualify a candidate or re-put them on the ballot?
That's why I kept repeating it, and it was annoying for people watching it. But that's why I kept repeating, this is the boring part. This is boring to me.
Okay, that's interesting because, and I might just be completely wrong, but my recollection of that conversation was, I feel like that was the part that I think Lauren was harping on, and it's not like you were saying that's actually the easier, boring part. Let's talk about the other part instead. But I might just have it confused in my mind.
Because I think what the audience cares about is justify Donald Trump engaging in insurrection and rebellion or giving aid or comfort to enemies, and use a standard that applies to Trump that wouldn't apply to all these other people. That's what they cared about. That's what I thought the audience cares about.
Sure.
And I have a lot to say about that.
Okay.
There are interesting, for legal people, there are interesting questions about whether this is self-executing, whether it requires a criminal conviction. Esports Batman is someone I think has no credibility on this question, based on. Sorry to be.
He was disagreeing. He was fine with you a lot.
I just and you know what? I'm gonna step back and say that was inappropriate. I'm sorry, Esports Batman.
No, that's all good.
I just disagree. I just disagree with Esports.
Yeah.
I just disagree with him. on it. But so there are some interesting legal procedural questions. There are some people, for example, who say this does not even apply to the president because the president is not, quote, an officer of the United States. There are people who say that, and that there's an interesting historical argument to be assessed about whether or not the president is an officer of the United States. I think it's obvious that he is an officer of the United States. Okay. But there are people who will strenuously, and there are even legal scholars, respected legal scholars, who say the president is not an officer of the United States. So those are like interesting legal setup questions. But I think the more interesting questions for our purposes is applying it to Trump. And you seem to think it was a foregone conclusion that that standard was fulfilled by Trump. I'm glad that that's your opinion, but aren't you worried about the comeback at Kamala Harris, given your question?
Well, that's why, like, I think that a thing can be fulfilled in one way, but like, I think that the legal question is different. Kind of like when we had a conversation about, like, I think it's almost undeniable that Trump like incited January 6th, but like from the legal grounds of like, would I charge him with incitement to riot or whatever? Almost certainly not, because it seems like there are very far-reaching ramifications for First Amendment rights if a president can be
I just want to put an interesting, I always say this and it's cringe as fuck when I say it, but I do want to make an interesting little flag here for you.
Yeah.
That I think the paper that you didn't read, but, and I don't honestly think, I don't know how useful it would be for you to read it. It's a legal paper. I think convincingly argues that whatever the standard is for criminal convictions under the First Amendment for incitement, that is the Brandenburg standard. That's the imminent, like, incitement to lawless action that we think is like a very, very high bar. That's the First Amendment standard, but the 14th Amendment was enacted after the First Amendment, right? And I think convincingly the Bod and Paulson paper argue, and almost I think disturbingly, but I think convincingly, that to the extent that there's any conflict, a true conflict between the First Amendment and the 14th Amendment, the 14th Amendment wins. And they have a lot of reasons why those conflicts don't actually exist, that a lot of speech-related stuff has never been protected by the First Amendment. But they argue, I think convincingly, that the 14th Amendment, to the extent of a true conflict, that's the standard you apply, not Brandenburg. Whatever the framers of the 14th Amendment would have thought was tantamount to giving aid or comfort to the enemies, regardless of it would fulfill some kind of protective speech under the First Amendment, because the 14th Amendment obviously was enacted afterwards, it would take precedence over the First Amendment.
Okay.
Does that make sense? And to give you an example, suppose that you were a Civil War supporter on the Southerner side, and you were telling people, you should go fight for the South. You should fight for the Army of North Virginia. That's very, like, you would agree, I think, that would, like, seem to fill our First Amendment principles, right? All you're doing is advocating that people join the Confederacy, right?
Sure. Yeah, there's a lower bar for the 14th Amendment. Some stuff would satisfy the 14th that doesn't satisfy the first. I understand that, sure.
Yeah. Okay, but so I guess that was a question about, so how does Trump fit in all this? Trump fits in all this because even if you don't think his speech at the ellipse rises to the level of incitement under, like, the criminal law, that's not the standard you apply. You apply the 14th Amendment in Section 3 of the 14th Amendment. And I think, given what the framers of the 14th Amendment would have thought about someone in his position doing the things he was doing, it very clearly, in my opinion, fulfills either engaging in insurrection, rebellion, or at the very minimum, giving aid or comfort to those who are.
Yeah, okay, so hold on, example, oh God, are we going to do this? Yeah. Is it going to happen? Is it happening? I understand what you're saying, and I agree with you, but I'm asking you, how was that determination made? That's the biggest thing, is how do you determine that he did do that thing?
So I think step one is defining out there's always going to be difference on the margins, but the safe cases of what is, like, working definitions for what is an insurrection and what is a rebellion. That's step one, right? How can you say that you're giving aid or comfort to insurrectionists or rebellionists if you don't know what an insurrection is or you don't know what a rebellion is? That's why it's so important. And the court has found, I think multiple courts now, that January 6th was an insurrection. It's so important to have that discussion.
Wait. And courts have found that January 6th was an insurrection. What do you mean by that? Has a court
under
made
the 14th Amendment?
Wait.
In New Mexico,
Has the court made a ruling? Or when you say a court, or do you just mean that?
A court. But of course, courts can disagree, right? The Supreme Court hasn't made that finding. But some courts have made the finding under the 14th Amendment, or have assumed for purposes of applying the 14th Amendment, that January 6th was an insurrection. But that's step one of the analysis. Agreed? Determine whether the thing that you are analyzing is either insurrection or rebellion.
Okay.
Agree? Or do you think that that's...
Yeah, I don't know if, like, New Mexico finding that it was, that in their purposes it was, what if Tennessee makes a ruling where they say it wasn't, and then somebody tries to bring a federal suit, then which prior ruling...
That was a throwaway. So
yeah.
The reason why I said that was just to tell you that there are courts who have made the assessment, not to say that the New Mexico trial court is binding on everyone else or will have the last word. Ultimately, the Supreme Court will have the last word. But just to show you that as part of the analysis, you would inquire into whether or not this was or was not an insurrection.
Okay.
And that's sort of, and to sort of meta it out a little bit, that's why I was bringing up Fort Sumter and clear cases of insurrection.
Can you, if I were to go through and look at that New Mexico case, do they literally use the word like insurrection, or do they just say like attack against like the government or something?
No, they literally use the word. You know, they make a finding that January 6th was an insurrection.
Okay, gotcha.
That's a finding of the court, yeah.
Okay.
And I think it's a necessary one, because if January 6th wasn't an insurrection, then Trump is cleared under that theory of the case. There's another theory of the case, which is the whole illegal, the fraudulent elector scheme, that is a rebellion. But I think that that's like a secondary theory, not the primary theory. The primary theory is that January 6th was the insurrection, right?
Okay.
So that's the first step, and that's why at the end of the conversation I was like, I want statements from you guys. Do you agree that it's an insurrection or not? Because if you don't even agree that January 6th is an insurrection, then you're never going to agree that Trump is liable. And
okay, I don't even know if whether or not I agree. I don't even think that's the question. I just feel like the question is like, who's the one to make the determination? Because like, let's say for instance that court case. What?
That's the procedure question, is who decides.
Yeah, no, but I'm saying, like, let's say it was the case that this particular county commissioner just didn't run again, right? Or wasn't convicted or wasn't there. Now we don't have New Mexico, like, state making that, like, peripheral ruling or whatever, right? Now what?
Well, that was a ruling that applied to a person who was in office.
No, yeah, I know, but I'm saying, let's say that guy wasn't there. Now we don't have that court case in New Mexico. Now we're just at ground zero.
We don't need it, right?
What?
We don't need that court case. We don't need that court case.
Okay, cool. We don't. Okay, I agree with you. I would hope not. But that's why I'm asking, like, who is making the determination then that January 6th was an insurrection, so that we can apply this 14th Amendment standard or whatever to Donald Trump?
Yeah. So this is going back to that first set of questions, and the answer is let's say the singular point of person who's determining qualifications. Let's say that person is just one guy, and that one guy is just the Secretary of State. If it's just Secretary of State, it's just that, as an initial matter, it's just that one guy who has to determine that it's an insurrection.
Wait, who?
Whoever the Secretary of State is, right?
Under what procedure is the Secretary of State declaring something an insurrection or not?
Okay.
Why can't he just say, the Supreme Court will decide?
Somebody under state office is empowered to make qualification decisions on the ballot. That is, they are the ones who are normally making the determinations as to qualifications. And that is the case in many states, where secretaries of states have to determine whether or not you fulfill the qualifications to be on the ballot. Do you agree with that, like, basic setup, that there are certain people that are empowered to make that decision?
Yep.
That Secretary of State comes to his desk and says, and there's a petition from some citizen that raises this issue, who just like tells him, hey, you should consider whether Trump violated Section 3. And the one guy says, I will. And you know what? I'm thinking about it for 10 minutes. Yeah, it was an insurrection. That one guy is the one who's determining it, right?
Doesn't that seem like insanely horribly bad?
Hold your breath.
Okay, go ahead.
Just hold your breath. Because it's just to show you that your question about who decides, anyone who has authority to make these qualification decisions, and that also includes Congress and state legislatures and judges and courts, all of them are making that determination. Now, the particular steps, right? Let's say that one guy makes a preposterous decision and he says, in my opinion, I don't know, when Biden tripped, that was an insurrection. That determination would then be challenged in a court, and then the court would be deciding whether or not it was an insurrection, and reviewing the decision of the Secretary of State, and having power over that decision, and determining, as courts are empowered to do, the arbiters of determining these legal disputes, they will now have the ability to decide whether or not the decision made by the Secretary of State comported with the law, and in doing that, they will have to assess for themselves whether or not it was an insurrection.
Okay, so then the answer is ultimately the who is going to be,
right?
So anybody can basically start this chain of process, but ultimately it's probably going to be a Supreme Court decision?
Right, yeah. So ultimately, right, so
also, wait, can I ask a quick random criminal procedure, because I don't actually know. Can you appeal like a standard murder case like all the way up to the Supreme Court? Has that ever happened where like the Supreme Court is ruling on just like a normal criminal case? What does that look like?
Miranda v. Arizona. That was a case there. I think there was actually 3 cases in that decision, but that was a state conviction of the Miranda guy is actually horrible, and he did some horrible shit. Those of you guys who like, I know you're watching like the JCS shit. I think he was like a rapist. He was or attempted murder, or he did something really, really bad. He was a weird guy, and that went to the Supreme Court on a federal issue related to the coerciveness of custodial arrests and interrogations. Okay. So you absolutely can bring a state criminal proceeding up to the Supreme Court, and obviously a federal one as well, directly, right?
Okay, gotcha.
But there usually has to be a federal issue for state proceedings.
Okay.
Not entirely relevant, but
okay. I was just curious. Okay, so then the answer is anybody. A lot of different people might be, because of the self-executing part of this, a lot of people might be able to make the determination that, oh, this was an insurrection. But ultimately, there's going to also be a lot of people a lot of injured parties, I guess, that would have standing to bring a suit, maybe a voter against, say, a Secretary of State.
Yeah.
And that
if you're ever confused, Stephen, imagine that there were a proceeding about the age of the candidate. Who would have, like...
I understand what you're saying there, but the age thing is far less interesting to me because those seem to be like much more hardline, lack of interpretation, undisputable facts. Like if a 5-year-old wanted to run for president, I don't even know if that ever goes to court. Like it's just so obvious. But insurrection is far more like a matter of interpretation. So
play it out, but play it out. Who has the power, right? Mm-hmm. So you wouldn't be uncomfortable with the Secretary of State being like, "I'm sorry, this is a meme. This is a baby. He's not allowed to be on the ballot. So no." And that one guy just decides, and you're okay with that, right?
Yeah, of course.
As a power, yeah. Mm-hmm. And then if the baby really wants to appeal it, he can go to the court and appeal it. And let's say the court's like, you know what? In our interpretation, 35 means something different today than it meant back then, and we're going to apply today. And so a baby is 35. That would, and let's say the appeal court, affirms that. That would ultimately come to the Supreme Court, right? Like, so that path, even though it's a ridiculous fact pattern and it's a ridiculous set of actors who are making these preposterous decisions, that procedure and mechanism makes sense to you, and it's not like some horrible.
I would caution you on this because this has already gone through in Arizona and it's currently going through in Colorado, and it's not the way that you think it is because Arizona completely shot it down when this was brought through their process, specifically on the point that there is nothing in the law that allows for them to judge upon this.
Yeah, so the
Arizona Supreme Court, yeah.
Arizona Supreme Court made a ruling contrary to my interpretation and these other scholars' interpretations of what the 14th Amendment says. That, you saying that, right? That's just someone who disagrees with us. So I don't understand.
Well, wait, hold on, just real quick. From a legal point of view, the most uneducated ho-dunk dipshit lawyer in the world has more authority over the law than the most intellectual Harvard Yale law professor ever, right? Like every academic in the world could theoretically disagree with, say, the Supreme Court or lower appellate court. That doesn't matter. Appellate court, it doesn't matter, right? What the courts say ultimately is what the law will be. No, so
yeah, I don't disagree. But it was important that the Arizona Supreme Court in this particular case sat there and said there's nothing in state law that allows us to adjudicate this kind of case. And you would have to have a specific provision with this, which sets up a very difficult and problematic situation under your section, because you could have states that sit there and say, for instance, oh, well, we're only going to adjudicate these kinds of cases in civil matters if it's unrelated to January 6th. But if you're somebody who gives money to Black Lives Matter, for instance, and they, engage in rioting or whatever in our state, we can consider that insurrection. And
can we pause? Can we pause this real quick? So just talk about one thing.
Yeah.
So because Stephen's not following right now. Steven.
Wait, why am I not following? Wait. Hold on. I don't need analogies. I think everything you said so far is fairly ordinary, no?
Yeah. And not only that, but to the issue is when we talk about the requirements for a finding of guilt, this is also supported by the history and the actions that Congress has taken.
Different topic.
No, it's absolutely the same topic.
No, it's a different topic, and I'll explain to you why it's a different topic. Do you mind if I?
No, let me finish. It's a gish gallop. It's a similar topic because we already have historical precedent for stuff like this happening, where after the Civil War, during the 1872 amnesty bill, as well as the 1898 amnesty bill for the Spanish-American War, they specifically sat there and said, hey, if you are found guilty of crimes related to this in the past, not only are we forgiving you for it, but it doesn't encumber you under the 14th Amendment to run for office.
Yeah, those acts have...
They specifically had that in mind for a criminal finding.
So those acts, of course, are acts of Congress that aren't constitutional law. And so you citing them shows that they took affirmative steps to clear people both of criminal convictions and of disqualification of the 14th Amendment. That pertains to the issue of whether or not a criminal conviction is required, and it's further it's preposterous that you're citing it. It's further evidence in my favor on that issue, the fact that they separated it out like that. But it's a separate issue entirely from the other issue you're raising, which is what happens if a state has no mechanism for adjudicating Section 3. Those are separate issues, correct?
It is, but it is to show that...
That's why I want to take a pause and do it one by one.
No. What it shows is two things. One, that there's no mechanism because nobody's ever accepted your interpretation of it up until this point. Until this law review article came out in Penn Law, nobody had this thought process behind it. And it's a very novel legal theory, and it's being propagated by, in particular, one attorney who represents the Democratic Party, which is fine. Like, I understand that some people... No. I understand relevant. The point that I'm trying to say is
well, hold on, wait, real quick. I think that it should stand on its own merits, but if we're talking novel legal argument that is being displayed in academia, not in a courtroom, then I think there's probably a lot of relevant questions around who's involved. Yeah,
I can't... This conversation is breaking apart because he's raising 3 or 4 different things at all different times. So I'm just going to list out the different issues he has raised. Issue number 1 pertains to whether or not what happens if a state has no mechanism to enforce Section 3. Issue number 2, is a criminal conviction required?
No.
Hang on. Wait. Let me finish, please. Let me finish, please. Wait. No. Esports.
Well, sure. Let Pisco lay out his 4 things real quick, and then you can...
That's fine.
So esports, Batman, I'm going to repeat again. One issue was whether, the question of state enforcement if there is no state mechanism under state law. Question number 2, what to do if a criminal conviction is required, which he thinks it is, and he raised evidence for that. Question number 3 now is the novelty of the issue and, opining about the merits of it based on its novelty. And issue number 4 is like whether we should trust it based on, who's bringing it. Those are 4 different issues, and you're asking me, like, you are incapable of addressing them one by one.
Well, hey, let's do let's do one by one then.
Let me address first of all 2 things. One, the who's bringing it didn't matter. The point that I was trying to make was that this is a relatively novel legal theory that has only been brought up to bear in the last 6 months. This is not something that has been openly discussed up until this point. So you can go away with issue number 4. I don't care who's bringing it, other than to say.
Okay, I want to do these issues one at a time, but you just want to go on a bunch, all your laundry list of reasons why.
Okay, wait. Hold on, real quick. To be clear, okay, I don't think he's going to whole laundry list of things. Okay, he said a couple things, but we can do it one by one. I think it's unfair to say he's attempting to gish you, but okay, do it one by one.
Okay.
Go ahead.
And then the second thing, right before he gets started, is that when I say there's no adequate way of addressing this in state law, I mean from a civil court case. Like that there would be a civil finding or some sort of a civil procedure for this outside of understanding that it relates to a criminal conviction.
Okay.
Yeah. So the first issue is like, Stephen, what happens if there is nobody who like state law does not empower anybody to determine, 14th Amendment qualification cases, and that's possible, right? That is entirely possible. That I've been talking about how different states have different mechanisms for enforcing it. It is possible that under state law, there is no mechanism. That's entirely possible. Nothing about that, number one, is incompatible with my understanding of the 14th Amendment, Section 3, or the people who are expounding this theory. That's not inconsistent. They say that's true. And that's true of Esports Batman's understanding of the issue as well. Because under his theory of enforcement, there would need to be a conviction, correct? And states obviously are not required to criminalize that conduct. And the federal government is not required to criminalize that conduct.
The federal government already has criminalized that conduct.
No, I'm sorry. They're not required to criminalize it. So it's not the case that it could be the case that no jurisdiction has enacted a criminal enforcement mechanism.
Wait. Hold on. You can tell me if I'm wrong. I understand what you're saying, that theoretically the 14th Amendment could have been penned without this particular provision being a criminal thing, but it is a criminal thing, and it was penned as it was a criminal thing. So I don't know how relevant that is. Right?
But I also want to point to something, which is that when you read the text of the 14th Amendment, as far as Section 3 is concerned, it says those who have engaged in insurrection were giving aid or comfort to the enemies of the United States. The point is that they're using the exact same phrasing and language as is given for the legal definition of what constitutes treason, the only crime that is provided for under the Constitution, right? They are specifically citing to the exact actions that constitute criminal treason. And then...
Okay.
Well, let Pisco address that. Go ahead.
Yeah. So addressing your point about the treason question, is it possible, is it constitutional for Congress to get rid of the treason statute? You understand there's a criminal part of the
constitutional amendment, yes, but without a constitutional amendment, no.
Absurd. So there's
in fact, let me go read the actual of the treason of what constitutes treason, because it specifically says that Congress can only set the punishment for treason. They cannot set the evidentiary standard, and they cannot set what constitutes treason. They can only set the punishment.
Could Congress pass the following law? No court shall have jurisdiction in the United States to hear any criminal case arising out of an allegation of treason. Is that constitutional?
Wouldn't the answer be no?
No.
Why not?
Because wouldn't it get reviewed by the Supreme Court, and the Supreme Court would review that the law is in contradiction to what the Constitution states, so you need an amendment to amend the Constitution to pass the law? Or am I...
Congress is not required to pass criminal statutes with penalties.
That's why it gives them it says specifically that Congress shall pass the...
Where?
Okay.
It doesn't say that. You know it doesn't. There's no requirement that Congress pass
Article 3, Section 3, Clause 1, treason against the United States shall consist only in levying of war against them or adhering to their enemies, giving them aid and comfort.
That's limiting what the definition would be. That's not an active requirement.
No person shall be convicted of treason unless on the testimony of two witnesses to the overt action or a confession to the court.
Again, Congress could get rid of all federal criminal law. Agreed?
Except for treason, yes.
That's bullshit. Come on. They could get rid of all trial courts. Esports, couldn't they?
No.
They don't have
Article 3 already stands for those courts.
Esports, they do not have to have lower federal courts. The only court that's
have I agree with you. Lower federal courts, they could get rid of
the Supreme Court would not have, as you're aware, the Supreme Court does not have original jurisdiction to just hear a random treason case. They're not allowed.
No, I agree that they do not have original jurisdiction.
So then I'm going to ask the question again: is it required for the Congress to pass any laws that to mandate federal criminal law? They could get rid of it all, couldn't they?
Well, hold on. It sounds like it sounds like we're asking a different question here. Like, if you're asking the question, could Congress pass a law to abolish all federal courts? That seems to be a different question than can Congress pass a law to make it so that they don't have to prosecute for treason? When it feels like
Congress had to enact federal criminal laws. They had to enact them. And if they had to enact them, they can get rid of them. And what's
but hold on, wait. But they didn't. It sounds like Congress did, and I could be wrong, but it sounds like Congress didn't enact the federal law saying treason is illegal. It sounds like I haven't read this, but
they did.
Wait, why would you need to enact that law if it's already in the Constitution?
And in fact, there's case law on this. It's called it's in Ex parte Bowman, which had to do with Aaron Burr and his Confederates. That was the whole point. And they sat there and said,
well, wait, hold on, we have a disagreement of fact. Wait, Pisco says that that's not in the Constitution. Is treason specifically called out in the Constitution, yes or no?
Yes,
is it?
Article 3,
treason is defined. treason is defined, but treason is the punishment for treason. The specific criminal statute for making treason a federal crime that has been passed into law by Congress, and
yes,
it's not self-enacting by
for the punishment. Yes, that's the reason why it's in there.
Congress. So let me just be real direct. Congress does not have to have any federal criminal court proceedings at all, correct?
What?
Isn't it the case that Congress never even had to make the federal courts, lower federal courts?
No, they didn't have to. They chose to, but they're not obligated to.
If they didn't have to make the federal courts, if they can decide to, you agree, they could eliminate them if they wanted to. Congress could get rid of all lower federal courts.
They could, but that doesn't necessarily get rid of federal criminal law. There are two separate different issues here. And this is the problem. You're conflating the existence of laws versus the adjudication of laws.
Does Congress have the ability to take away jurisdiction from state courts of federal criminal law? They do it now.
Yes.
Okay, so then if Congress has the power to take away jurisdiction of state courts for federal criminal law, and Congress has no obligation to pass any criminal statutes or indeed have any lower federal courts, how can you say that the treason federal law is required in the Constitution?
Because it specifically provides for it in the Constitution.
No.
Yes, it does.
So it's self-executing.
Look, you're the only person that seems
so are
to
you
have
saying
this
it's
thought
self-executing?
process.
Wait. So is the treason clause self-executing?
Is the treason clause self-executing?
Out of law from Congress.
Yes.
So why isn't the 14th Amendment self-executing? If that's your comparison.
The 14th Amendment is self-executing upon a conviction. Yes, I agree with you that it is that if somebody is convicted criminally of treason or insurrection or sedition, all of which historically are the same charge, it just depends on the individual facts and circumstances as to whether or not you're acting as an individual or if you're a part of a group or if you're acting violently or non-violently, then yes, I agree. If you are convicted of insurrection or treason or anything of the sort against the state, yes, you are automatically disqualified the same way that an individual who is otherwise convicted of a crime could be sentenced into slavery, which is the 13th Amendment's second section, right? Where, involuntary servitude is banned except as a punishment for finding of guilt in a court of law.
I think hold on. Wait. There's a huge disagreement of a fact right here that I feel like we need to resolve before we go any further. Okay. So this is my feeling, okay? And I think we need to resolve this. Otherwise, there's literally no point in going further. It is my opinion, okay, as the legal scholar, Wikipedia, okay? It seems to be the case that if Congress wanted to pass a law, or I don't know how they would do this, pass or get rid of in the criminal code that treason is like a crime, basically. It seems that Pisco is saying that Congress could do that, and it feels like Esports Spam is saying Congress can't do that. And I feel like since treason is the only specific crime specifically called out in the Constitution, I feel like they can't do that. I feel like you would need a constitutional amendment to do it.
Agreed.
Can we? Well, I know you. Wait, but Pisco disagrees. But that seems like a really important fact. Now, Pisco, hold on. Do you think that they can actually just get rid of that, or are you saying the only way they could get rid of that is to destroy all of the adjudication measures that the federal courts have by abolishing the courts? Or do you think Congress could actually just make a law or rescind from the criminal code treason and say, oh, that's just not an illegal thing anymore without an amendment?
All of those. I think Congress could, without an amendment, treason is defined in the Constitution, but the federal criminal code is not self-executed by the Constitution. And Congress, if it wanted to, could deprive all courts of jurisdiction as one method to get rid of any kind of treason.
So then,
no federal court.
Yeah, I understand what you're saying. But let's say the Supreme Court reviews this. Then, how does the Supreme Court interpret what you're saying to be true when treason and convictions of treason are specifically spelled out in Article 3 of the U.S. Constitution?
Simple. It's very simple. The Constitution defines what treason shall be as a ceiling. The whole point of it was so that treason could not be defined in a flippant way to be something that's silly or stupid, and then you can just kill people for talking bad about the king or the president or whatever. Treason was defined particularly as a limiting principle, but it is not this powerful thing that exists independent of federal law. And the proof of the pudding of this is easy. if Congress put some particular additional procedures for treason-related, indictments, they would have to follow them. And so, how can Congress put additional limits, additional procedures, additional stuff in the text of their treason clauses and have it be of their definition of treason or in their, the statutes, and have that be enacted if it were
because I think that because they're building upon what's already in the Constitution, not directly standing in contrast to what's in the Constitution, right? Like if the Constitution said Article 5 or whatever of the article of the section of the blah blah blah, if they said eating Skittles shall be a crime punishable by whatever in the United States, Congress might be able to pass a law saying, like if you eat Skittles, it has a minimum fine and you can outline some other things, but Congress wouldn't be able to pass a law saying, oh, actually eating Skittles is okay. We're getting rid of that part of the Constitution.
So let me offer a counter alternative that gets Pisco where he wants to go, right? Although Congress could not do away with treason itself as far as whether or not it's a crime or not, they could impose, and similar to like the ACA, there's no actual penalty for it, right? It's a fine of $1.
Oh no, they can make
it
zero.
The evidentiary requirements, you still have to. It's still a crime, but it's
toothless. So you're saying that
it's toothless effective.
Wait. You just said. Hang on.
Which
you
is
just said
why Congress can only provide for the punishment; they cannot provide for the rescinding of the actual charge of treason.
This is what Statman just said. He agrees with me that Congress could set the punishment to 0 years in prison, 0 time in jail. They could set the fine to 0. They could remove all jurisdiction from any courts to hear a treason case. They could do all that stuff. But they can't just get rid of the treason.
Wait, hold on. Yeah, I feel like that makes perfect sense. Like maybe
makes no sense.
I not only disagree, I think you're wrong. I'm pretty sure that like the procedure is important. Like if somebody tells you that you have to enforce a crime or execute a thing or whatever, then that's fine. But if they don't call out the specific punishments or whatever, then you can.
And we see the same thing with the ACA now, right? Like the penalty is $0 if you don't have health insurance.
So to be clear, to be 100% clear, I disagree with this interpretation.
That's
but fine. even if I accept it, right? Sorry, my voice is cracked. Even if I accept it, then that means your criticism of the Section 3 and saying it would be such a horrible world that we would live in because you could have it so there wouldn't be enforcement in the states. That's true of treason too. So on all levels, it's parity with Section 3 of the 14th Amendment in that any state or Congress, if it wants to, can make the criminal-related aspects of these, the constitutional provisions toothless and non-enforceable.
And that's the whole point of like what we did to the ACA, right? We removed the penalty for the.
But then your criticism falls away if it's true that because what you were saying, just to review for everybody, is.
But it's still the law, and it's still on the books. It's just
you're saying
effectively toothless, as you said.
Let's review why is this even relevant. The reason we're talking about this is you criticize my interpretation because you say it's absurd because states could remove their procedures for enforcing Section 3, and wouldn't that be an awful world to live in? And we shouldn't read it this way because the treason clause, which the language is taken from, is it's a strong clause that is self-executed and all that stuff. But you just admitted that Congress or any state, if it wanted to, could render it toothless, just like in the Section 3 of the 14th Amendment case. And so your criticism of my reading of the 14th Amendment falls away.
No, it's still there on the books. It's still enforceable. It never goes away. That's the whole point. Your choice.
We have these type of cases all the time. Like there are nominal. Sorry, go ahead.
Yeah, there is prosecutorial discretion in whether or not you choose to follow through with stuff all the time. Excusing that, right? Like just on that basis alone, then your entire thing falls away if somebody chooses never to prosecute a particular case. That doesn't mean that it's still not on the books. That's the whole point.
So you're criticizing the version of Section 3, which is enforceable by not just criminal convictions, because you're saying it's possible.
You believe it to be self-executing, Pisco, you have to accept this, right? Because it's the only situation in which it's self-executing. Otherwise, its execution depends on a external. Do
you understand my criticism of your criticism?
I do. You're sitting there saying that by rendering it effectively toothless, that and not providing for a way of doing so, it's the same as if there is no structure in the first place.
I'm saying regardless of the reading, regardless of how you read Section 3, with the appropriate legislation, it can be rendered toothless, regardless of how you read it. That's my point.
Agreed.
And you just admitted as much. And so it doesn't matter whether we take your approach or my approach. That the question about like this awful world in which Section 3 is unenforceable, that possibility exists in both cases, and in fact is more likely in your case.
The difference here is that in order for you to do that, you would have to do all the things that you have just outlined. Like, right? Congress would have to do away with the prosecutorial power. They would have to do away with the lower courts. They would have to make the punishment toothless. But your entire reading of that section, as far as the 14th Amendment, is that it's self-executing. That's your whole thing.
No, hang on. No, because I don't even. I say that maybe one of the pathways in which it can be enforced could be through criminal process. Mine is not exclusive of that. I have not taken a position that says one way that you couldn't, as a tag-along penalty to a criminal conviction.
Are you admitting that the Section 3 is not self-executing?
No, I am not admitting. Hang on. To be unequivocal, I am not admitting that. I think it's self-executing, and you think it's self-executing. We both think it's self-executing.
Yes.
The question is who enforces it, and how do you enforce it, and in which way is it self-executing? And what I said is, you're pretending that my enforcement mechanism precludes a criminal proceeding.
No, I never said that it did.
It's not. It doesn't preclude a criminal enforcement mechanism. It's not exclusive.
Wait, can I ask a question? Mechanism. Section 3 has been enforced in the past, correct?
Correct.
Yep.
Has it ever been enforced absent a criminal conviction?
Yes.
When?
After the Civil War in New Mexico.
Wait. Was it enforced such that somebody tried to run or do something and they were barred, or was it enforced in spirit because the people didn't even bother applying for the jobs?
It was enforced. It was enforced by people who were elected to office.
Was this as a result of the people who were non-grant?
So hold on, just to be clear, just so that I can understand, and I'll go look this up in case. So you're telling me that there were some people that were like, I'm going to run for office, and then a state secretary, somebody said, no, you're not going on the ballot, and then they were like, oh, fuck. And there were no charges, no convictions, that just happened.
It was a different procedural posture. In the after the Civil War cases, people were actually elected.
Yes.
And they were and
Which
they
is
were
where
not
the 1872
seated.
amendment and amnesty bill came into play.
They were not seated by Congress, and obviously that's not a criminal conviction or proceeding, correct?
Well, were they not seated because they were expelled?
Will you answer that? Will you answer that question?
Yeah, that would not be that case. But my question is on two. I'd have to look more into
Okay, so
history.
then you're admitting if I'm representing it truthfully, then that's a case right after the Civil War where Section 3 was not enforced.
Can you cite me that case?
Sure.
Because I want to know.
Didn't you read the Baden-Paulson paper? They cite a bunch of them. There's like 8 or 9.
Yep. I'll look it up because I have it downloaded.
Okay, then you should go look. But if that's true, do you agree that my reading is better than yours?
No. Because I think ultimately it was all taken into account during the 1872 Act.
Wait, so what do you mean it was all taken into account? We're talking about a point in time before the Amnesty Acts when the Congress did not seat duly elected congressmen from the southern states because of Section 3 without a criminal conviction.
They are who I think they are, and if I remember correctly, they were people that were specifically exempted from the amnesty bill, where they sat there and said certain people were not given amnesty.
This is before the amnesty bill.
Yeah, when they were still Confederate.
What do you mean they were? I mean,
because there were Confederate individuals sent to Congress during.
The 14th Amendment is a Reconstruction Amendment.
Okay.
The 14th Amendment was enacted.
You're right. I will grant you that. You are correct.
Okay, so the 14th Amendment, after it was enacted, Congress, a bunch of Southerners who were Confederates, were elected, and Congress didn't seat them. That's not a criminal conviction. And what's more, and in the more recent case in New Mexico, there was a conviction for trespassing, I think. There was no conviction for insurrection, for rebellion. I'm assuming you're not going to say any criminal conviction could do. If you have a DUI, then that's fine. You can Section 3 his ass. I'm assuming that you think there has to be a parity. It has to be an insurrection charge that you're convicted on, not just any charge.
Hold on, because I believe this was through congressional rules as opposed to the 14th Amendment.
I.e. not a criminal. I.e. not. Well, no. I'm sorry. The basis of
there's a difference between choosing not to seat somebody when they're duly elected and expelling them from Congress versus them being completely alienated from their civil rights to run in the first place. You understand that these two are separate.
14th Amendment. Wait, so is it your position the 14th Amendment can be enforced without a criminal conviction?
No, it can't, because it's a disqualification and a removal of civil rights. There's a difference between the rules of the United States Congress, which allow for them to expel members of Congress, right? And even state Congresses have this rule. That's the whole Tennessee issue that popped up not too long ago with the Tennessee 3. There's a difference between removing individuals pursuant to the rules of the House in which they serve versus disenfranchising. No. Versus versus disenfranchising their civil rights to run in the first place, right? And as we saw with the Tennessee 3, just because they were removed and expelled did not prevent them from running again, which is why they retained, the 2 of the 3 retained their original seats through special elections or through committee votes. That was the whole point. It doesn't completely disqualify them from ever running it for any office.
Can Congress allowed to enforce Section 3 of the 14th Amendment?
No.
Congress isn't allowed? So then what they did was unconstitutional?
They can undo it, though. How can they not do it? Because at the end it says that by 2/3 they can remove such disability.
Yes, that is the only exception to the rule. But as far as removing an individual from Congress, the problem with Pisco right now is he's saying that a removal of an individual from Congress, or a censure, for instance, is the same as a disqualification of civil rights to be qualified to run for office in the first place.
I never said that. What I said was, can Section 3 of the 14th Amendment, what I asserted was, Section 3 of the 14th Amendment can be enforced without a criminal conviction. And I cited to you examples of that in the past, and I want you to answer. Was it constitutional for Congress after the Civil War to not seat the people who were...
Wait. Can I ask a clarifying question on here? Because I understand what you're asking, Pisco, but I'm going to expand on what Esports Batman, I think, was saying, or at least what I meant. When I said without criminal conviction, okay, I didn't mean just criminal conviction. I mean without criminal conviction or some other sort of recognized procedure. So for instance, if you're going to say, oh no, Section 3 was enforced without even a criminal conviction, and you're telling me like one congressman was just like, nah, get him out of here, that would be something. But if you're saying they found ways to expel them or not seat them because like Congress was allowed to take a 2/3 vote on who could be seated, I feel like that's a different type of thing.
No. So there's an assertion here. The assertion is that the only way to enforce Section 3 is through a criminal conviction. That is either true or it is not true.
So then when people were not seated...
If it's possible for Congress to enforce Section 3 in any way, then that assertion is not true.
Sure. What is the enforcement then? When you said that they weren't, because I'm searching through this paper and I can't find what you're bringing up. I'm sure it's in here. I don't know what to search for. When people weren't seated in Congress, did one congressman stand up and go, Section 3, get this guy out of here? Or did they take like a procedural, like a 2/3 vote that they could do to like remove anybody from Congress for a variety of reasons?
Congress is the determiner of its elections. The Constitution grants Congress the authority to determine the qualifications of its members. Everyone agree with that? Who's a lawyer?
Okay, so then does this mean that like absent...
Wait, can you say agree or not?
Yeah, so then that means that then theoretically any of these guys could have been removed from Congress absent Section 3 then, no? Or...
Right, just like any... But the basis was Section 3.
Yeah, so but I mean like the basis could have been you smell bad if the House votes on it, yes? Or do they need to call out a particular reason?
But that's just saying Congress that you can't trust anything Congress says when they say that they enforce it based on some constitutional provision.
Well, I guess what I don't understand is because it sounds like we're saying that like Section 3 empowered them to kick people out. But it sounds like they literally could have kicked any of these guys out for any reason. This wasn't Section 3 was the vital...
It's a basis. It's a basis under which to to do it.
Yeah,
right?
but does what I'm asking is, does Congress have like a list of like, you've got 4 reasons you can kick someone, or could they have said, hold on, I think these guys literally were part of the fucking Confederate. We don't want to seat them because we feel like they're enemies of the United States without even invoking Article or Section 3 or whatever. Yeah.
Historically, okay, what happened was in the 39th Congress, they refused to read and swear in the members of the Confederate States before considering the readmission to the Union. That was the whole point, is that there was all these obligations and responsibilities that the former Confederate States had to undergo in order to be re-allowed into the Union. And during this time, Congress, as a matter of their policies and procedures, simply said, we're not going to allow those members to participate. They did not sit there and say, hey, we're removing you under Section 3 to say you cannot run again as a member of a office, or your civil rights to run for office are hereby curtailed. That is not what happened, which is exactly what I thought was the case. So this is an entirely different aspect to sit there and say there are rules for Congress to limit members' participation in Congress, but that's different than taking the enormous step without criminal conviction of removing someone's civil rights to go ahead and run for office in the first place, even if they were otherwise qualified.
There's 2 confusions there. The first one is, I guess, this question of whether Congress, using its qualification powers, could ever enforce the Section 3 of the 14th Amendment. Are you? I just want to be clear, Setsu. Are you saying that there is no way through the qualification authority that Congress has to enforce Section 3?
What? No. I wait. He asked me. I thought he said that's.
I'm sorry. Esports. My bad. Whoever just talked, I got confused.
No, Congress doesn't have the right to qualify whether or not a person retains their civil rights to run for office.
No. I'm sorry. Can they prevent under Section 3 of the 14th Amendment someone who, a Confederate soldier who would previously took an oath, who tried to kill Lincoln? Could they prevent him from being seated under Section 3 of the 14th Amendment?
No, that would require a criminal conviction.
No, it doesn't.
Okay, that's it doesn't.
Pisco's right.
Yeah.
Like you read Section 3. The thing is, I get technically Pisco is correct that it does not say in there. All it says is you can't if you've engaged in insurrection or rebellion. It doesn't say how we actually determine if you have, because there's certain things like the Civil War. There's not really an argument. Like there's not really like someone going like, you know what? I don't think us seceding really was a rebellion. No one's saying that. But the problem is once you get into an area of gray where people are like, was this or wasn't this? Congress just deciding, yeah, we're good enough for us.
Yeah. Suddenly, I understand what you're saying. I think that the confusing part is it seems like initially Pisco was saying like this was a huge Section 3 invocation, and that's how they prevented these guys from doing it. But it feels like what Eastwood's Batman is saying is like Section 3 invocation sounds like not only are you not going to be seated, you literally don't have the right to run for any office again. But it sounds like what Congress did was Congress is like, we're not going to seat these guys, and because of this. And then that was
when we say it's
self-executing. Section 3.
When we say it's self-executing, that means the thing that disqualifies you is the amendment, right? 14th Amendment just does disqualify people. The moment you engage in insurrection or rebellion or give aid or comfort to the enemies thereof the Constitution, you're disqualified.
Well, no, sure, we understand that, but that's we weren't. Wait, we weren't asking that. I think the question was, hold on, but that's not the question, Pisco. We understand all that. The question was just the very factual, basic question was: has anybody actually done this before without a criminal conviction? Has somebody said you are not allowed, you are never running for office again without a criminal conviction? And it seems like the answer to that is no.
Yes, in New Mexico.
Well, no, in New Mexico, yes, but I'm saying, but hold on, that was off of a criminal conviction, wasn't it?
No, it wasn't.
I'm sorry, wasn't that guy criminally charged with trespassing and being part of?
But that's not what he's saying. What Esports Batman is saying is you need to be convicted of insurrection or rebellion or giving aid or comfort.
I thought part of the judge's finding was that it was an insurrection. I thought that was part of what the judge found.
No. Yes. That's a separate civil proceeding. That's a civil proceeding, right? Do you agree, Esports? That's a civil proceeding.
I have to read up on it.
It was. Just take my word for it. It was a civil proceeding, and the finding of insurrection wasn't in the criminal proceeding related to this individual.
Esports, were you saying that it needs to be a criminal conviction of insurrection?
I do believe that is the case. Now,
what's
New
the basis of
Mexico.
that?
No, hold on.
Functionally or technically? Like, so I mean, like, so do you agree in Section 3 it doesn't say that? Technically, Pisco's right. Functionally, I think esports Batman should be like that. We really shouldn't go with just like, well, it doesn't tell us how we find out someone's in sexual rebellion.
Here's the problem with the interpretation is that, and this is what I was getting to earlier, to sit there and say this is a very novel legal substance that has been brought up, right? There is the New Mexico case, but in contrast, there's also the Arizona case where they sat there and said, no, you do actually need a conviction. We don't have a civil methodology for dealing with this, and we do expect there to be a criminal trial for insurrection or treason before you bring this to us to disqualify an individual.
Even asked if there was ever any case. The answer is yes.
Yes.
Well, wait. So okay. So besides the one case recently, it seems the answer is no, even for the Civil War people. That nobody.
The answer is still yes.
Okay. I'm sorry. So then, can you point me to who was told that you are never allowed to run for office again without any criminal conviction? Not who wasn't seated in Congress, but.
No. Okay, that's what that's the failure to understand, in my opinion, with respect.
Okay. Gotcha.
So,
okay.
And that's why I start all these diatribes saying everyone has a responsibility to enforce the Constitution, including Congress people, right? And so, in the way that Congress would enforce Section 3 is through their qualification powers. The way that Congress would, enforce it as against the president is through their impeachment power. The way that Congress would enforce Section 3 as against
tell me if this feels like an wait, because you're just saying 50 million examples, they're all the same shit. We understand. But so here's a question. Let's say somebody says in Congress, we're going to Section 3 not seat you here. Couldn't theoretically somebody still run for a local office and they don't challenge him there, and then he?
Yeah, but the way to enforce the local seat is through another proceeding. Does that make sense to you? Right? So like Congress is not in charge necessarily, doesn't have the qualification powers as to the state legislative seats. They only have a specific set of powers. And so yeah, Congress's determination as to Section 3 is limited by their actual authority.
Sure.
But that's not the question.
Okay, so then so then the next question is, it sounds like then for this Section 3 execution, you need 2/3 of what, both chambers or one chamber to enforce it, or what is the
I don't know the specific qualification.
Well, in Congress for the Civil War, it looked like it was 2/3. So does this mean that Section 3 is toothless if you don't have 2/3 of Congress to enforce it? No.
2/3 can undo it.
Yeah, 2/3 requirement allows them to bypass the prohibition. So let's say you're an individual who is found guilty of treason or insurrection. If you still wanted to run for office and you could get 2/3 of both houses of Congress to vote for you, then they could sit there and say, okay, Pisco, he was found guilty of treason, and we really like Pisco, so we're going to go ahead and vote for him to allow him to run for office again. And that once you receive those 2/3 votes, he would be free to run for whatever office at whatever level again.
No, I agree with that. That would be
and that was the point of the amnesty bills, is to avoid that on a case-by-case basis, to give a large, sweeping general amnesty to everybody and say the 14th Amendment's disqualification doesn't apply to you if you were part of the Confederacy or if you were found guilty of a crime related to treason or sedition or whatever before this date.
Agreed on the amnesty legislation, all that. But think about how ridiculous esports proposition is, right? After the Civil War, there were potentially like a ton of previous oath takers, right? At least hundreds, I think you guys would agree, of previous oath takers, if not more, if you're including military people. If you're including military people, maybe even thousands of individuals who took up arms against the Union. And obviously through limits in resources in terms of enforcement of federal law, you're not going to be able just practically to do all these conviction charges or all these insurrection charges against everyone who previously took an oath.
Which is one of the reasons why they went ahead and did the amnesty bill. Hold on.
Is that one of the reasons, or you're thinking that?
Yeah, they did it because they did it. Well, I just want to finish this thought because he's interrupting me. It would be preposterous to think that Congress wanted this extremely expensive go through every one of these thousands of people who took up arms and go through convictions for all of them. That's not the process they had in mind.
When you look at the text of the Amnesty Bill of 1872, they specifically lay out that it's a general amnesty for everybody with the exception of certain people, and they outline the people who are not given amnesty because they specifically sit there and say, hey, like, look, you were part of the people that were the leadership of the Confederacy, you were the high-ranking military generals, you're not just some guy from Mississippi who joined the Confederate Army, you're actually somebody who needs to be held accountable, and so you are not given amnesty, you are not free from...
Why are you bringing up the Amnesty Acts? Like, that doesn't matter, does it? Why should the Amnesty Acts influence our interpretation of Section 3, except insofar as, you know, it has some assumption about what the actual standard is to apply to this?
I was piggybacking off what you were saying as far as, like, the difficulty in, like, going through individual trials for each individual person who may have been involved, which was one of the underlying reasons why they did this broad amnesty bill. Was
so they made a stupid amendment then.
Reconstructionist efforts and to kind of reconcile the differences between the North and the South and to heal the wounds of the war. All of this.
But then that's a really stupid amendment. That's a really stupid amendment. So what you're saying is, like, okay, they knew that they had potentially thousands of applicable people, and they intend, even though there's absolutely no record whatsoever in terms of, if you care about legislative history or debates, there is no record that where they ever say the words like, oh yeah, and they're going to have a criminal conviction about it. Like, none at all. And
why
it was just understood
for the
that's later in time. That's later in time pursuant to the second sentence of Section 3, which gives them the power to remove the disability. But that has nothing, like, there is just no evidence that when they were drafting this thing, they thought that they needed a conviction, and it just would be such an impractical mess for them to.
No.
You know,
why does the text of the 1872 amnesty bill include a amnesty from criminal prosecution as well?
Because those are separate things, right?
Because one is not capable without the other. You cannot have a deficiency, and because treason and sedition do not have statutes of limitations. That's the whole point.
That's your assumption is that you can't have it without a conviction. That's begging the question. What we're talking about here are two separate penalties. One is you're literally sitting in jail, or you're pursuant to an indictment to a conviction where you have some burden placed on your liberty. I don't know what the fucking burdens were back in the day, but presumably you're in jail. That's one set of penalties, and the separate one is the disqualification from office. Makes total sense to treat them separately, and that's what they did, and that's evidence in my favor.
No, it's not evidence in your favor. It's evidence in my favor because you're sitting there saying, look, we understand that later on down the line there might be additional trials beyond the passage of a general amnesty for the 14th Amendment. We don't want people to get tripped up on that technicality to sit there and say, hey, later on down the line, 20 years, we're going to prosecute people. And because the amnesty was given then and it was backward looking, which is, again, something that is mentioned in the paper, or the law review article specifically, you would need it to be giving a amnesty for criminal conviction. Otherwise, you could just wait until an amnesty bill is passed, and then literally the day after it's passed, go ahead and sanction someone or prosecute them, and then render them disabled from running for office.
There's nothing incompatible. I mean, like, I think it's a bunch of blabber. There's nothing incompatible with them separately listing out the disqualification and the conviction. None of that is incompatible with my reading. I just gave you a very common sense reason why they would separate it out, which is they could decide, right, in their discretion, you know what, we are going to remove the disqualification, but you're going to keep the conviction. You're going to serve your time. That could be one approach. Or they could say, you know, you're going to keep your disqualification, but you can be out of jail. They could choose either of those paths.
Then you wouldn't need to give criminal amnesty then, right? They gave both criminal amnesty and they gave disability amnesty. And they did the same thing during the Mexican-American War, too.
No, you would still need to give both, right? If it's the case that if it's self-executing like I think it is, then the disqualification amnesty applies regardless of conviction. And so it would be a broad, forward-looking amnesty where no one has to look behind their back at any kind of disqualification. Likewise, the criminal conviction amnesty would apply to people who've been actually convicted. And also it could be forward-looking in the sense that we're not going to prosecute you in a later time.
Forward-looking. That's the whole point. That's why you give a sweeping amnesty at that time to both. Because
forward-looking in the sense that no one has to look behind their back. No one has to look in it, like, okay, you're clear. Yeah, that's what I mean by that.
But assuming that that's the case, you would have to have both, because at the very least, if it were just a matter of disqualification that you were worried about, you could do it in two separate bills. You would also sit there and say, we could limit criminal liability under certain circumstances, but disability wouldn't be the issue, right? Or you could sit there and say, on a case-by-case basis, we're going to go ahead and consider the removal of the disability.
They could have done it a bunch of different ways, esports. They could have done it a bunch of different ways. They chose to do it all at the same time. There's nothing incompatible about doing amnesty for both conditions, the conviction and the disqualification. Nothing about that conflicts with my reading of the 14th Amendment. Nothing. It is totally compatible with my reading of the 14th Amendment.
That's fine.
And what's more is, it doesn't, even if it were incompatible, it wouldn't work to amend the Constitution. It's later in time. The Constitution is the supreme law of the land. So even if there was a conflict, the Constitution is not amenable to amendment by the Amnesty Act.
Can I try and bridge just like what I think is happening? So I think Pisco is technically correct. The Section 3 does not require a criminal conviction. And same thing for like the Civil War. We didn't have, like, there wasn't even a need, like the Section 3 doesn't require it, and there was no one in dispute. They signed a piece of paper saying, hey, we're rebelling, like there wasn't something that we needed to really do about that, and Section 3 doesn't require it. However, outside of like that, a civil war, when you're trying to say, did someone involve in insurrection or rebellion, you really shouldn't just go off your own little like, well, I feel like they did. Suddenly, so courts, I think you said like in Arizona, where they're saying, no, I want a criminal conviction because there can be a self-limiting, even though it's not required of them, when determining whether there's an insurrection or rebellion. If you're a responsible person in power, you probably should have something to lean on more than like, I feel like it, because technically I don't need anything more than that.
I mean, I don't have a problem with that. I mean, like, I don't have a problem with you saying that like some states could require it for their own process or whatever, but people like
self-limiting, not like, so doing it almost like, to be more convincing.
Self-limit. Yeah, they're totally within their discretion to do so, or states are within their rights to say, hey, we don't hear Section 3 claims under state law, and no one is empowered to enforce Section. The state could pass a law if it wanted to and say, no one in our state is allowed to enforce Section 3. That's okay, because Section 5 of the 14th Amendment allows Congress to enforce Section 3. And so it's not required for states to make available Section 3 related claims. There's, with some caveats, there's some federal court precedent that says that you have to make your courts available to federal suits. I think the case is called Testa. So there's some caveats to what I'm saying, but in general, if a state could take certain moves to limit the avenues for Section 3 application in the states, or to channel them through particular processes, I don't have a problem with that. But I'm responding to a criticism, which is that Section 3 absolutely requires a criminal conviction, and I'm glad that you agree with me that it doesn't.
And
You're correct.
I would disagree, and the reason why I would disagree is because I would offer to you the Victor Berger example, where he was specifically prevented from taking office after his conviction under the 1917 Espionage Act, where they sat there and said, hey, you were specifically done with this, and it's only been invoked twice since the Civil War, in regards to this, for people who were found
guilty. It doesn't counter
Pisco's
point.
It doesn't counter Pisco's point, but what I'm saying is, it goes towards my point to show that there is obviously a historical precedent requiring a conviction under the law for espionage or treason or sedition, and that this reading that Pisco is
requirement, no, but they really, really should, is the way I put it. I don't know required to, but them not doing it is a pretty massive thing. In order for it to be
self-executing, it can only really work if it's required for a criminal conviction, right? Like
you just said espionage. Wait, espionage is not insurrection rebellion.
They're basically the same thing. Yeah. So giving aid or comfort to the enemy.
Espionage isn't aid or comfort to the enemy?
No, because no. Hang on.
No. Hold on. I'm going to disagree on this.
Maybe I'm wrong.
Treason, sedition, and espionage are all the same thing. Yeah, no.
They are not.
Yes, they are. The only difference between the three is whether or not violent action takes place or whether or not it's organized or individualized. The reason why treason is included in the Constitution specifically is because it's the widest net that they could catch with regards to actions. And in fact, if you want to go look at Old English common law, it was generally understood that treason, sedition, and insurrection are all the same thing because they all involve acts against the crown.
I'm sorry. They are not the same thing. So I'll just give you an example.
The same thing.
I want to hear Pisco's reason why.
Okay. So, is a Russian spy who is in the United States for the Soviet Union? Let's say Soviet Union. He is gathering nuclear secrets for the Soviet Union. Is he engaged in insurrection or rebellion?
Potentially, yes. Depends on whether or not he's acting alone.
Is he by definition?
Sedition or insurrection?
Insurrection, rebellion, no. But it doesn't say or given aid or comfort to the enemies thereof.
Yes.
No. Okay, listen. Giving aid or enemies.
Oh, you're
right.
Making
war against the state. Making war against the state is.
Pisco's right. Fuck. Pisco's right. No, he's right. It says insurrection or rebellion against the same, or giving aid to the comfort to the enemies thereof, as in aid or comfort to people who are committing insurrection or rebellion.
Yes.
The Soviet Union is not doing an insurrection or rebellion.
So let me offer this interpretation. Okay, sedition is typically providing aid or comfort.
Sedition.
Sedition's in there.
Let me get you. Okay. Let me just hold on to your pants. Okay, sedition is the act of encouraging others to take action against the government. It is nonviolent typically by nature, but it is also organized, right? Insurrection is organized, but it's organized violence against the state. Treason, it can be either violent or nonviolent individual acts against the state. In all situations, they are crimes against the state. And that is making war against the United States. It doesn't have to mean that you're from a foreign country. It does not necessarily have to be that you are, an individual here in the United States. The basis is to make war against the United States or to provide aid and comfort to its enemies. That is the definition of treason. And if you go and look at in Old English common law, all three were used interchangeably. And the reasoning why is because it had to deal with acts against the crown. Right.
Okay. So, this is ridiculous.
Treason was. It could be considered treason to attack members of the royal family, for instance.
Wait, can I just ask a question, just real quick? Is there case law? Like, are there people that have been sentenced under anything to prove any of this, or is all of this just?
So the individual that I just cited, Victor Berger, was disqualified under Section 3.
It was lifted.
Because of his conviction for violating the espionage.
Oh, no. I meant, is there proof of like the sedition, treason, all of this being like essentially interchangeable? Like, have there been...
Yeah.
No.
Sedition and treason isn't
okay, hold on,
wait.
This is so easy. Pisco is saying no. Esports Batman is saying yes. There's a factual claim. Can somebody just prove their claim? This should be very easy.
Yeah, 100%. The United States, like the definition for espionage.
Wait, no, we're not talking. I understand the written definition. So right now, I think the onus is on esports. Batman, you need to provide like a case where it's used like interchangeably, or court says they're interchangeable, or somebody that did what looks like the letter definition of espionage or whatever is charged with treason, or vice versa, something like that. Should be.
But hang on. But
it wouldn't be treason. It would have to be insurrection.
Okay.
I can disprove them with the Constitution. The Constitution defines treason.
Well, no, I don't think that matters. Does it? Because he's saying that irrespective of the definition, he's saying that legally they're used interchangeably, and that one is just a broader definition that comes.
No, hang on. No, that opens a can. Wait, I just want to speak real quick. That opens such a big can of worms because the state can define espionage however it wants. Trump has been charged under the Espionage Act. The state could define espionage to be whatever it wanted. This is not what was intended.
If the state can define it however they wanted, earlier it sounded like you had a big issue giving that definition of the Russian. You're saying, oh, well, it's clearly this thing. But now it sounds like you're saying, well, no, I guess it could be any of those things.
Let me offer you the legal definitions, okay? This is in the Title 18, all right? So sedition is noted as if two or more people in any place subject to U.S. jurisdiction conspire to overthrow, put down, or destroy by force or wage war against the government. forcibly oppose a government authority, preventing, hindering, or delaying the execution of any law in the United States, or seize, take, or possess any U.S. Property contrary to its laws. Meanwhile, insurrection under Title 18 means whoever incites, sets on foot, assists, or engages in any rebellion or insurrection against the authority of the United States or laws thereof, or gives aid and comfort thereto, shall be fined under this title, imprisoned not more than 10 years. And treason under Article 3, again, shall consist only in levying war against them or in hearing
they're different.
Treason against the United States shall consist only in levying war.
Wait. You just admitted. Wait.
About waging war
incredible.
Or engaging in violence against the
state. It's incredible. Your own definitions just disproved you. As you were saying them, you realized it, because treason is much narrower than sedition, which I don't know why the fuck you're talking about sedition, than sedition and insurrection. And insurrection is narrower than sedition. So
no,
you, in your own definitions, you just clarified.
In fact, let me go back to the Title 18 for insurrection, and it says, comfort shall be fined under this title in prison not more than 10 years and shall be incapable of holding any office under the United States. So it specifically says, even in the Title 18 code, that it specifically calls back to Section 3 to say, hey, like, look, we're only upon a criminal conviction for this are you barred from holding office.
Yeah, okay, but I don't know why you're bringing this up.
And to conspire to overthrow or wage war against the government is sedition. Like, again, that's the definition of treason as well. Right? To wage war against shall consist in levying war. Waging war versus levying. Are we really going to cut that hard? No, we're not. It's the same thing. That's sedition literally says waging war against the United States is the crime of sedition.
Why are you bringing up sedition? Yeah, why are you bringing up sedition? I mean, you have to answer that.
Because they're all the same. That's what I'm trying to explain. Like, all three
are the same. Sedition is the same as insurrection? Sedition is the same as rebellion?
Yes.
But then why would insurrection or rebellion are the same thing? Then why would they say insurrection or rebellion? Why would they name out those two?
Because there's a small difference between insurrection and rebellion depending on whether or not violence is used or non-violence is used, which is why treason was used in the Constitution when it was ratified, because it's the widest net possible. It included both violent and non-violent crimes against the state.
But treason isn't in there either. Neither treason nor sedition are in there, or in Section 3. Neither of those words are in there.
Yeah, true.
But they all involve making war against the state.
I agree.
There's an espionage there. Espionage in there. I don't even know. Like, espionage, this is bedrock, because you're saying espionage, sedition, insurrection, rebellion, treason. They're all the same.
I'm saying sedition, treason, and insurrection are all the same. Espionage is different.
But if treason was the widest net, why wouldn't they say treason? If treason is the widest net and they wanted to have the widest net, why wouldn't they just say treason or rebellion?
Say treason. Yeah.
Because they already do by saying making war, waging war against the United States, right? Shall be guilty. What is?
Well, no, but they don't say that in Section 3.
Yes, they do.
Wait. So
it says,
would you be, if you were convicted of treason under the Constitution definition of treason, would you be disqualified under Section 3?
Yes.
That's silly though. Then what? Like, surely they would have recognized, if they intended for that, there would have been some attempt to harmonize those two statutes. Why have this weird process?
The same language for what constitutes treason is in Section 3, right?
No. The language relating, I would say,
in insurrection or rebellion against the same, or giving aid or comfort to the enemies thereof, right?
Yeah.
Giving aid or comfort to the enemies is literally the statutory definition for treason. To make war or to give aid or comfort to the enemies of the United States.
Give aid or comfort to the enemies thereof, and thereof is referring to the insurrection or rebellion. So, like, it can't be something other than the insurrection or rebellion. If you're giving aid and comfort to enemies,
period. Rebellion, but making war against the state, which means making war against the United States. That's the definition of treason.
I feel like
America being at war with Mexico isn't insurrection or rebellion. America at war with Mexico is a war between states. No one would have seen that as insurrection or rebellion. That's invasion. That's a foreign invasion.
I don't think we call. Yeah, right. I don't think we would call that insurrection or rebellion against your being. If you sell a secret, if you're a military guy with secrets and sell it, I mean, I agree with you on functioning sports, but
okay. Then why did they pass an amnesty bill for the Spanish-American War?
Because there was presumably some
Wait, go get. So more about that. Say. speak.
So there was similar to the Reconstruction Amnesty Bill for the Confederacy that we just talked about. There was another amnesty bill that was passed in 1898 for the Spanish-American War.
Yeah, because in the Spanish-American War, weren't there allegations of Americans like being part of or being like traitorous to America? And also just because
you do insurrection via war. So like if they were like, hey, overthrow this state and we'll give it to you, but help us. Like, and then you're like, and we'll give you part of this thing, then that would be so like.
Yeah,
I don't think that's what's happening.
Making war against the United States, which is
so you could do treason and insurrection, but I don't like that. I just feel like we're jumping kind of far. We're like skipping rocks between each one to go like, well, technically this could be this, and this is this, and this is this. Therefore, let's clear it all the way back.
All three come down to like a concept of you are doing something to fight or make a war against the state, to challenge its authority or to overthrow its authority. Right? All three have this like common thread definition. Which
espionage could be anything. Espionage could be
against the state to stop it from being able to function or to overthrow its authority.
Espionage could be just like, stealing some dirty little pics.
I didn't include espionage. I said sedition, treason, and insurrection.
But I thought you brought up
No. I brought up the issue of the Espionage Act being a disqualifying measure, but included in the Espionage Act is sedition.
I'm not seeing this amnesty bill. Where is there a name for it beyond that? 1890 amnesty bill?
Yeah.
We're far afield. I mean, I don't even know what we're talking about anymore.
Well, we're talking about because if he's right in insurrection, treason, those were all used interchangeably, and that it was intended in Section 3 for that to mean treason as well as those, and those require convictions, then yes, you can skip rocks to say yes, you need a conviction. But the problem is that Section 3 doesn't say that. The problem is it doesn't say anything. It says shall engage in insurrection or rebellion. It doesn't say, because it could have said if you are convicted of insurrection or rebellion, then you can't serve office, but it doesn't. They could have written that. And like usually when it comes to these things, when they're not written in, there's a reason why they don't write things in laws. Like these things are are argued by both sides, going like what words should and shouldn't be in, how should we word these things, and so like you can't read into laws that aren't written there. Even if you go like, okay, technically, I think Esports Batman is correct that functionally, absent like again a civil war, you really shouldn't just on your own fucking feelings go like, you know what, I feel like
separate issue. That's a separate issue.
I know, no, I agree with, so Pisco, I'm saying you're right on this, but I feel like that's the ultimate, like they go, even if you're right, they don't have to. Watch, would you agree with that, Pisco? They don't have, they can not have a conviction. They really should have a fucking conviction.
I don't agree with that. No,
you think they should just do it on a whim?
I don't think they should do it on a whim, but the choice is in between.
Absent, well, no, if you have nothing. So
if there's no conviction, it is a whim, right? I mean, that might be a good whim, but it's a whim, right?
And then we're left with, and we're doing what Desmond said, where you go, suddenly we can get rid of Kamala Harris. Why not? I mean, on my whim, if I feel like it, it's good enough. And I'm saying it's simply a norm that you're going to create that goes, you're letting whims aside. Because right now, whether it's an insurrection or not is debated right now. I don't think there was no debate over whether the Civil War, like I said, they signed a paper going, yeah, we're totally doing this, bros.
Invoked the Insurrection Act. They invoked the Militia Act, citing it as an insurrection right after they attacked on Fort Sumter. So I agree. There's no debate. That's why I was like, Destiny was being a real five-head when he was like, I don't know if Fort Sumter was an insurrection, actually, because he just wanted to be a contrarian.
Hold on. No, wait. That wasn't about a contrarian. What I didn't know is what you guys literally just argued was if another state is fighting against you, if that counts as an insurrection or not. If somebody declares themselves as a ceded territory and then they fight against you,
they weren't another state. They were Rebs. They were Johnny Rebs.
Well, but didn't that come after they had declared their secession from the Union?
Yeah, but that wasn't a... We won. They didn't actually do that.
Hold on, wait. So are you saying that? Hold on. So retrospectively, then, like if they would have won, though, wouldn't they have said it wasn't an insurrection? Like, I'm curious. When the United States declared themselves,
no legal effect.
When the United States declared ourselves independent from Britain, was that an insurrection?
It's Donbass.
Yes, that was an insurrection.
Okay, so my question wasn't because Pisco, you're trying to say like, oh, he didn't even want to admit this. I just don't know technically, legally, if it counts as an insurrection or not, right? For instance, in the Donbass, where they've declared themselves a separate state from Ukraine, is that legally declared as an insurrection? Okay, that's fine. That's great, but it's not about being a contrarian. It's just that when we're talking about the actual specific terms here, I think the terms are really important. I don't know legally if there's a legal definition for insurrection. Obviously, it feels like an insurrection because it's literally a fucking rebellion, but I don't know if that's a thing that is like post hoc defined based on who wins or loses the war. I'm not sure about that. That was the only reason I answered that.
Yeah, I'm fucking with you, bro. I understand it. Yeah, listen, we can just cool it. I fucked up again, guys. I was supposed to go this a whole different approach, and I'm sorry.
I think okay here. Outside all like the huge legal talks, because I don't know how we keep getting here. I don't know if it's Pisco's fault or my fault or somebody else's fault. Absent all the legal talks, it feels like at the end of the day, the question is, and I feel like you're going to say, oh no, Steven, there's just those two basic questions about it because we're just missing each other. It feels like it's really important to figure out who's deciding if an insurrection happened and if somebody else participated before people start getting stricken from the ballot. And I feel like we're no closer to answering that question than we were at the very beginning of the...
We are closer, Stephen. We are closer.
Are we?
Because
it feels like we literally just said that like it could be done on a whim, which doesn't feel any closer.
No, I didn't say that.
Okay.
When people say whim...
Yeah, what does a whim mean?
When people say... Okay.
No, let him define that. What does whim mean?
When people say whim, there's an implication that I did not want to onboard, which means that, which is like sort of it's done capriciously or done without care. That's what I think when people say something was done on a whim.
Okay, gotcha. I'm sorry. When we use whim here, and maybe Esports 5 means it more disparagingly, but I'm thinking like without like evidentiary standards. Like, he's decided that like, that was an insurrection. How do you know that? Was there a process? No, that's just that's my personal.
Hang on. So the initial step made by state agencies will be a much lower threshold in the kind of evidentiary burdens that would be required.
Sure. Wait. To be clear, let's be clear. Zero threshold. There's no threshold. It would just be their
whatever's
thought.
in your mind.
Yes.
Right?
Okay.
It's a whim.
So,
a whim.
No, but okay, but I think what would actually happen is that state agencies would hear like petitions from people, but they could not, right? So it's possible that someone could be bad faith, just like it's possible that a court could be in many cases. But I agree that there's
it's not bad faith. If a Democratic Secretary of State right now struck Trump from the ballot, you wouldn't say that's bad faith. You'd say, they're probably acting in good faith. No,
without thinking, right? Like if someone did it without research, whether they
don't have a research. It doesn't say that. There's nothing in Section 3 that says you need to research it and determine it.
Yeah, Pisco's just saying that like how they made the decision.
Can you chill, bro? So I am just not saying that any state action is by necessity done on a whim. There are a lot of agencies that have their own regulations for how they come to determinations. There's equivalents of the Administrative Procedures Act in states, and so it's not the case that there's no evidentiary burdens in every state agency decision. The only reason why I'm saying that it's not necessarily on a whim is because it's not the case that any state action is done just by one person. That's the only reason. I'm just caveating it there. I agree that it could be possible that one Secretary of State could make that decision, but my response to Stephen's concern is, don't worry. There will be a trial, or there will be an evidentiary hearing in a court of law, and they will apply an evidentiary standard like they did in New Mexico. And so the concerns about one person running amok, those are fake concerns.
Sure, but then I guess what I don't understand is why is it at the very beginning of the... I feel like you could have short-circuited this entire conversation by going, well, tons of people upstanding, tons of different ways this could make its way through the courts, but inevitably...
Didn't say that.
No. You literally at the very... No, you gave a ton. You could have just said, it'll probably be decided in the Supreme Court.
Wait, chat, come on, chat. I did say that, didn't I?
Wait, no. Like, you could have short-circuited the whole thing by saying, it'll probably end up in the Supreme Court. You got there eventually, but it took like...
You're trolling me.
Wait,
you're trolling me.
All right. That's okay. That was my feeling. I might be out. Maybe I'm being contrarian. I guess I don't know. But it feels like you literally at the very beginning you could have just said like, "There's a ton of ways you could get there. It'll probably get to the Supreme Court, and then boom, that's it." Like it feels like that could have been an easy. Maybe you did say that, but it took like an hour to get there. I guess.
People concede Pisco the technical like there's things that Pisco was technically correct on that people weren't conceding to, and Pisco demands that he's right. It doesn't require those things, but he is saying that like yes, we will have them, but I feel like we don't need to like. That's what I'm saying. Like it feels like the boring conversation to talk about the technicality. Do we technically need a conviction?
I've been saying
technically no. But I know, but people aren't conceding that aren't conceding
sure, technically no, but then that would move to the next part of the conversation, which could be scary, which is like ultimately, are we looking at a 6-3 conservative court to determine whether or not a conservative presidential candidate is allowed to be on the ballot, which opens up a whole other host of scary.
Wouldn't that make it if they said yes, if they go no, he's disqualified, wouldn't that give it a lot of legitimacy? To go like to feel pretty strong about, because I mean it would be bad if it was a 9 like progressive court that every single one of them had been like spamming how much they hate Trump, and then they go totally insurrection. That wouldn't have much weight.
Well, no, I agree with what you're saying, but like what if they decide the other way? What if the court says something along the lines like it's not we're not in the determination of like deciding if it was an insurrection or not. We feel like we don't have to.
Shouldn't we find out?
Sure, we can find out, but have you ever heard the term "fuck around and find out"? So what if we do find out, and what we find out is the conservative court goes, "It's actually not our job. We're not ruling on this. This isn't we're not making this determination of whether it was an insurrection or not. That's the job of the Supreme Court." And then they just say
someone else does then, and they might be seceding it to someone who's like, I don't think they'll do that because that means they're giving this option to someone else. They have to say like it's not our decision.
But then maybe they do
anything about it and hands it off to Congress.
Or what if they say that like we're just going to send this back and say every state can make their own determination. So now we've got different fucking presidential ballots in every single fucking state.
And we're starting to see that too now in the states because certain states are starting to specifically say this is what constitutes insurrection and this is what does not.
That's what the Constitution says.
Section 5.
What?
Wait, but that's what if the Supreme Court says that that's what the Constitution requires, we should follow the Constitution.
No,
that's the whole point of
we should amend the Constitution. That's a dog shit procedure. That a different presidential ballot exists in every state.
No. What I'm saying is, if you trust our system and our institutions, like you might have a policy reason to amend the Constitution, and I probably would agree with you, Stephen. But like, it shouldn't be a basis for us not to find out what the Constitution says. We should find out what it says.
The problem with that, though, is that one state determines essentially the entirety of the eligibility for the individual in all states, which is a stupid thing to do. Because you could have a state like California sit there and say, actually, what Trump said, what Trump did actually does amount to insurrection. Therefore, he is categorically nationwide banned from ever serving office in any capacity.
Bro.
Meanwhile, you have a split between the jurisdictions where Texas says, "Oh, by the way,
I was gonna say, like, what if we end up in a world where like
go.
25 states have rulings for 25 different January 6thers, and they say it wasn't an insurrection, and then 25 states say it is? How do you reconcile that in like a federal forum?
Yeah. So the Supreme Court, if the Supreme Court says we're not going to decide whether this is an insurrection in states, you just decide, that would be like a chaotic ruling. Agreed. Like, there would be no other way to say that.
And that's literally the point that I was trying to make when I sat there and said you have the Arizona issue, and you were like, oh no, that's you're going at three different things at once. It's like,
no, but I don't think
the
Supreme Court would answer the question. I don't think the Supreme Court would say, we are going to not give effect to, or we're not going to determine this question. I think that the Supreme Court would, and at the very least, we would know what the procedure is. What you're saying is like, I'm scared to find out what the procedure is, and so I don't even want to bring it to the Supreme Court because I don't want to find out if the actual
because I'm saying I know what the procedure is. It's if it's self-executing. Once you're found guilty of one of those three, you're disqualified, and there's historical precedence for it. And it not only offers the highest burden of proof required in order to show that it is an insurrection, a seditious act, or a treasonous act.
You just totally changed the conversation.
Can't the Supreme Court find that? If the Supreme Court found that, then wouldn't that be enough? And if you trust the Supreme Court, then wouldn't they do that?
In a criminal finding, yes, I would trust that. Absolutely.
The Supreme Court has to make that determination.
Here's the other thing. If you're going to take away someone's civil rights, we all understand that conceptually that there is some sort of a criminal legal process that has to be attached to that.
Civil rights. You do not have a so just to be clear, there are two things I want to say to that. One, you do not have a God-given right, a legal entitlement to be the president of the United States.
Whoa, no, hold on, wait, that's not what he's saying. He's saying to run for president, no? To run for. That's a way different argument.
You have a right to run for office if you're qualified. Yes, you do. The same way that you have a civil right to run, to vote.
You don't have a right to be the president.
And in order for that...
No one's saying you have the right to be the president. We're not talking about being the president. We're talking about even being able to run for president, to be on the ballot, no?
Not only that, but to look at it through the voting context, right? You would say everybody's got a civil right to vote. Even though we take voting rights away from felons, we can only do that to individuals.
I want to test this. Do you have a right to run for president if you're not qualified to be president?
No.
Not if you don't meet the constitutional obligations.
Okay,
but
so
if you do,
then everything you just said was useless. Then everything you just said was useless.
I'm 35 years old.
Wait, hold on.
I'm 36. But I could run for president.
I think we would agree. I think we could agree then, like Pisco. So if the Congress passed a law saying that like only white people can run for president, would you smile and say, "Oh, so if you're black, you think you can run?" Blah blah blah. Well, what about the law right now?
No civil rights violated.
Wait, hang on. No, it would violate the Equal Protection Clause. That's what would be violated.
No, it would violate the constitutional civil rights of the individual who meets the obligations under the Constitution, right? We don't sit there and say, "Oh, okay, well."
I'm just curious. Are there non-constitutional limits on who can be president, like the 35 years of age? Are all of these constitutional? Or
born in the United States?
Constitutional. I mean, there are some filing requirements as far as the states are concerned to get on the ballot there, but as far as physically announcing,
I have a question. Esports. Can I ask?
No.
So wait, because one of the requirements you'd be born in the United States. I mean, so we have people who are U.S. citizens who vote here who are denied their civil right to run for office. Are you actually? Well, no, actually, maybe.
No, because it's constitutionally. So look at Arnold Schwarzenegger. Great example, right? He was governor of California. He could never run for president because he was born in Austria.
Oh boy.
Right? But if he ran for president, wait.
Those are spelled out in the Constitution, right?
But so is so is Section 3. Section 3 is constitutional. So everything about Section 3 is constitutional. So my question for you is the same question. If you are not qualified to be president, do you have a right to run for president? Did Arnold Schwarzenegger have a right to run for president?
No, because he's not qualified.
Okay. But so then everything you said
is just listen.
Perfect.
Just listen. It's the same thing with regards to the second section or the second part of the 13th Amendment, right? In order for your civil rights against involuntary slavery, your protections against involuntary slavery to be taken away, you have to be found guilty of a crime. That's the whole purpose, right?
Yeah. Okay. So there's
absent those initial requirements of the Constitution.
It's beautifully brought up for two reasons. One is the 13th Amendment specifically specifies, and Stephen, listen to this, the 13th Amendment specifically specifies a condition under which a criminal conviction is required for an exception. That is, you can be put to involuntary servitude if you are criminally convicted.
Yes, agreed.
So on the one hand, it shows you that the people
conviction when they need to.
They say conviction when they need to because they said it in the 13th Amendment and it's absent in the 14th Amendment. That's number one. Number two, everyone agrees that you have a right to property in this country. But the 13th Amendment, in an instant, in a second, in the self-executing fashion, the minute it was ratified, absolutely and totally extinguished the property rights related to persons that everyone who had, a slave at that time. So the Constitution can extinguish liberties just like that and can impose new qualifications in a second.
It was not an absolute,
the 13th Amendment.
It was not an absolute property right because the 3/5 clause. We also counted them for representation. You cannot count property for representation.
Okay, but there's always limits. There's always limits. There's a takings clause on property, as you're aware of. So it's no right is absolute. And so just like slavery was, absolutely a qualified property right, but it was a property right entitlement. And there was no due process associated with the extinguishment of your right to own people.
The entirety of the constitutional amendment process. That is your due process.
But Section 3 was enacted. Section 3 was enacted.
Why is a conviction required?
You don't have a right to
Why can't the Supreme Court hear the arguments with evidence like the J6 report, statements from Trump, etc.?
Arnold Schwarzenegger had no right to run for president because why? He wasn't qualified. And so you're not going to be able to make a short circuit around the question of whether Trump is qualified or not under Section 3. And you're trying to be cute with it by bringing up, you have a right to run for president. Sure, if you're qualified to run for president.
If you're qualified, if you're not qualified. Hit the age, if you hit the specific qualifications, you have a right to run for office. Yes. And to take away someone's right to run for office is the same way as to take their right to vote away, which we only do under due process in a criminal conviction. Why is this so hard to understand?
That's absurd.
There are two sides of the same coin.
Okay, so
it feels like you're saying
I'll ask you a question.
I was gonna say that it feels like you're saying you're removing their civil liberties as it's almost like a fundamental thing that how can you, even if it says it, even if we can interpret it as not needing it, it's such an important thing that we need to have it. But at the same time, we're like,
that's
why can't Arnold
vote, one person initiative?
But person I'd go okay, but we're kind of denying civil rights of citizens who weren't born here. That's pretty severe, and we just kind of do that without. I
feel like the difference though is that these are we have what is a full citizen of the United States. We have those requirements that are spelled out specifically in the Constitution. And two, the big thing is these things aren't decided, I don't want to say on a whim, but it's not like we're just deciding who can or can't, which is subject to interpretation like this insurrection thing is. I feel like that's a scary part. At the very least for Schwarzenegger, we all agree there is no debate on what the Constitution says. It's not saying that if somebody seems for instance, if it were to say, if it seems like somebody has more of an allegiance to a foreign nation than our own, then they can't be president. That seems highly problematic.
Okay, so that would be dumb.
I agree with you that the point of it, so the point is to say that it doesn't technically require a conviction. I would say it would be batshit crazy, absent like a civil war, to not use one. I feel like saying like the Second Amendment, technically you have the right to bear arms, but you don't have the right to bullets, and so therefore it does technically not say you have a right to bullets, so they can ban bullets.
Well, you don't have a right to bear arms. You have a right for the states to organize a militia, which is the National Guard.
Okay, let's
get into a separate issue. Holy fuck. That's a separate issue. Jesus Christ. You just triggered everybody in the chat.
I am going to fucking kill you. With my right to bear arms.
So what Steven just brought up is a very interesting example. So he said, wouldn't it be like fucked up if there were just like, you're disqualified if we think that you're being a little sus? If that were like the constitutional.
Well, they kind of addressed that in the constitutional requirements, which is why you have to live the last 17 years here in the United States.
Yeah, but if there were a dumb provision that said you can't be president if you're sus, we would have to fucking interpret that, right? We would have to enforce that. We'd have to determine what does sus mean, and guess what? There would be a ton of proceedings about, if you're sus, if you're not sus. And so all of a sudden, it would explode litigation. It would be inconvenient, but it would be constitutionally enacted text, and we'd have to enforce it.
It would be, but I think something that would help us is that sus ruling would probably be tested a fuck ton. And then we would have like really solid case laws, like this is clearly sus because of this and this and this and this. Whereas for this shit, like in the whole Reconstruction past the Civil War, like how many times has this even been invoked?
Not only that, but also
how many times has this happened?
Hold on, look at the qualifications as what is required to be president, or to run for the House, or to run for the Senate. They are very quantifiable. They are not. It's either yes, no. It's a very binary argument as to does this person meet this qualification.
It could be a different. It could be a difficult factual question, and like suppose that there was actually some difficult fact question about where they were born, and tie with that like some legal questions about maybe they were born on a military base, but the military base is like this weird pseudo jurisdictional part of
but it feels like at the end of the day those facts come down to a non arguable, like there's going to be a fact of the matter, and that's going to be the end of the discussion.
But hang on, someone's going to have to. So like, let's say it's a difficult fact pattern on both age and where you were born. If you're a natural born citizen, you don't have a problem as an initial matter. A Secretary of State being like, "Sorry, dude, you can't be on the ballot."
What are you, even a baseball player from South America? Age would be difficult to parse.
Dude, come on. There are people who are born without birth certificates.
Sure, yeah. So I think the interesting question would be a guy comes up, he wants to run for president, but he's from a very small town that has really shoddy record keeping, and he produces a birth certificate that was created 6 years after his birth, and he's 34 years old, and there's a real question as to, is the birth certificate accurate, or should he have to wait one term, because he could be 34 or he could be 35. Exactly. That could be a real fact pattern that could exist.
That is fair. I'll give you that. But generally speaking, these are very quantifiable limits.
But we have these hypotheticals to test our priors about the institutional capacity of certain actors to judge things. And you wouldn't have a problem with the secretary. You wouldn't be like,
well, I think the problem there is that like it's a different question of probability, because at the end of the day, there's going to be a ruling that's going to say, probabilistically speaking, it was 60% this, 40% that. We're going to go ahead and lean on the side of the record keeping wasn't good, you can't do it. When it comes to an insurrection, this isn't a probabilistic thing where somebody's like, I think it was 60% an insurrection. There's going to be people given all the facts. Some people will say yes, and some people will say no. That's unique to this determination, which doesn't apply in any other. I don't think there's any. I think it's unique in character. It's not like any other example you could give where it just might be difficult fact patterns. Well, this is all the facts can be laid out among two people. One go, that's not an insurrection. Another goes, yeah, that is.
This is why it's difficult, because it's not just a factual discrepancy. It also relates to intentions. Everyone agrees that both insurrection, rebellion, giving aid, all that requires a particular mental state. Even though I don't think it's a criminal thing, just that what it is to be an insurrectionist or rebellion or to give aid requires intentionality. And so there's going to be probabilistic evidentiary standards applied to the facts about whether or not Trump had a particular motive to do a certain thing. And so that's going to be a difficult question, not just on facts, but on motivations. And then there's the additional wrinkle of the legal question inherent in what is an insurrection, and then applying that to the facts of the matter of January 6th. I totally agree with you, Stephen. Much more thorny, much more difficult than even the difficult fact pattern that I produced for the guy who is from the town or from whatever, right? Agreed on that. But that's what the Constitution says. And if it's yes, the standard for disqualification is much more open to interpretation than the other standards for the qualifications. But the procedure should be, and there's no basis to think that the procedure is different than it would be for the other qualifications. The only difference is there'd probably be more evidence put on, there's going to be more attention on it, and it's going to be funneled through the court system. But that's not a basis to not enforce it. That's not a basis to not find out what the rule is by going to the Supreme Court and finding out.
I don't think anybody's saying we shouldn't enforce it. I think all of us here, I would hope, I think all of us here would agree that if somebody's involved in seditious or treasonous activity, they should probably be disbarred from running for future. I think all of us in here agree with that.
Yes.
But I think it's incredibly important, might be more important than any part of this, is to figure out what the enforcement of that looks like, hence the Kamala Harris question.
Yeah, and that's...
which we haven't answered. We've talked every time I want to have this discussion about facts and distinguishing Kamala Harris, but we always get tripped up on, I think, this is just a question. Yeah, the technical, which is, and the technical, I think, is boring to the chat, boring to a lot of people. I know it's interesting to you, Stephen.
How would the Kamala Harris thing look then in your eyes?
Yeah, so in my eyes, this is how it would be different. One is in the cases of the people that she's bailing out, I don't think that she's giving aid, or even if you agree that the specific incidences were insurrections or rebellions, which I think you can fight on because there's a certain, in the working definitions of insurrection and rebellion that the writers in the Bowden and Paulson paper provide, which I think are quite convincing. I think there's a level of significance that's implied by them that that for certain of the protests wouldn't meet the bar. For some riots and for some violence that occurred, which definitely, in my opinion, would meet the bar, I don't think that you can say, just like the act of someone offering to pardon the January 6ers after the insurrection has been stopped, that can't be construed as giving aid or comfort to the enemies after their insurrections are not being insurrectionists.
Wait. If Donald Trump would have started a legal fund for posting bail for people that were involved in January 6th.
Yeah. So it's perfect. It's perfect. So let me explain how. If on January 6th, when people are in the Capitol, Donald Trump comes up and says, guys, I will pardon everyone who's in the Capitol. Everyone here agrees that would be giving aid or comfort to the insurrectionists, correct?
No,
Okay.
It wouldn't. It would be exercising the pardon power.
Come on.
No, the thing is, you're using the pardon power to, like, you're saying, like, I will give you, you're basically saying that. You're like, I will give you guys aid, and here's how I'm going to do it. Like, I want you to do the right...
Yeah, what if you phrase it this way? What if you said, please, 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 make me the president, and if it turns out wrong, I will pardon you. Come on. That one you're going to bite.
Because of the way the pardon power is looked at, pardoning is, like, the one thing I wouldn't agree with, but if he sat there and said, like... Yeah,
okay. I think it's
because the pardon power.
We don't need to fight. I don't think we need to fight on this one thing. I think you can just
wait. Hold on. Wait. Real quick. Was Flynn pardoned?
Yeah.
Yes.
Okay. Flynn was accused of lying to the FBI relating to things having to do with lying to a call that he had with Kislyak, I think. I don't remember.
Yeah.
Let's say theoretically he caught a charge. They decided to indict him for, I don't know, for treason or espionage or something, right? Does that mean that Trump now, or if Trump would have been the one to pardon him, does that mean that Trump now is on the hook for aiding and abetting an enemy of the United States?
No, because I don't think somebody. So what the gentleman, I forget his name, David, guy who stole sub-secrets, was giving them to Israel, got prosecuted for it, and I think Obama pardoned him to send him back to Israel. And it was part of a deal where he would get to go free, and then the Israelis would take him in. I wouldn't say that Obama's guilty of treason or sedition.
He's announcing it, right? Like, so let's say that he announced what's his name? Justical. Actually made a good point.
Justical.
This is Justical. He actually made a good point. And he said the announcement of the impeachment power of the pardon power is not the usage of the pardon power. So Trump goes out and says, "Hey, if you do it," he uses.
Okay, yeah, I think we would agree with that. It's kind of like when Trump was at his rally, and Trump literally said, like, listen, if you guys beat him up, I'll pay your legal fees. Like, you could probably argue that if somebody does something that
I want esports to agree with it. This is your problem, Destiny. You don't wait for that. So esports, if he said the words, "I will pardon you if you do an insurrection," or while you're doing an insurrection, don't worry about it, guys, I'm gonna pardon you. You agree? That's giving aid or comfort.
I don't think this is a big ask, esports. I get what you're saying, but
I think we've already had conversation about preemptive pardons are really problematic. I think that's we can all agree with that.
Actually, there is no allowance for preemptive pardons. It's the one limit on pardons is that you can't give preemptive pardons. So it wouldn't hold true. The other thing is the pardon power is supposedly absolute without any consequences constitutionally. So I don't know if you want to open up that can of worms. So no, in that particular case, I would not grant it to be 8 or
okay. Then okay. So I'll just move on.
Okay, the rest of us do though. Okay, go for it.
Yeah. Okay. So but now, let's say that the insurrection is quelled, and afterwards Trump says, "I don't think that was that bad. I'm going to pardon you." I don't think in that situation it would be giving aid or comfort. The temporality of it, when you are offering the pardon, when you are leveraging the pardon, matters. If Kamala Harris is standing in front of the courthouse and saying, "I'll get your bail funds. Get in there. Go burn it," or announcing preemptively, go and start violence. I'm going to pay your bail funds. That would be different than Kamala Harris after the fact, just like it would be different for Trump after the fact to offer pardons.
So then you would be amenable to the idea that if Kamala Harris had announced we are going to have bail funds for protesters, that she's disqualified from whole...
For people, I would think that there would need to be more particularized evidence.
Well, no, hold on, because it's not up to Kamala Harris determining it, because Trump could just say, "I didn't think it was insurrection," right? It would be up to a court or something.
My opinion.
Right? Oh,
but you're asking if I'm the judge, if I'm the person, if I'm the assessor, and someone comes up to give me this this case, and I don't actually know. Josiah is messaging right now, giving me fucking secret hints and telling me it was a general bail fund. But suppose that she actually said, if anyone does violence, I'm gonna bail you out. So don't worry about that. In advance, I would say that you were and let's say that you had some, there were insurrections in the past in terms of the violence, rising to that legal threshold, and she does it on a going forward basis. I would say, yes, you're giving aid and comfort to insurrectionists. If you were like incentivizing, if you were sending and funneling money to the people in the Chaz zone, come on. I would agree that those people were giving aid or comfort just like if you were funneling money to like the Whiskey Rebellion who like took over, like let's say they're taking over some part of whatever jurisdiction, that would fall like right into, if you're literally giving money to people for the purpose of them continuing their insurrection, of course I would agree that that's giving aid or comfort.
Well, not only that, like sedition also includes
wait, real quick,
disrupting the ability of the U.S. to enforce its laws. So by the very you could.
Well, here's a tricky one. What about during like civil rights stuff? If you were somebody that was intentionally donating to a civil rights protester, knowing that they were going to engage in forms of protest that were disruptive to governments,
Dr. Martin Luther King.
Yeah, does that count as aiding? No. Why not?
No. So,
well, wait. Sorry.
Does that count as insurrection?
I don't think that civil disobedience or the kind of acts that I would say some civil rights people would. Might fall on if it were like, think about the LA riots, right? The LA riots, guys. If it's focused against or something where the LA riots, let's say they're focused on government buildings as opposed to like a generalized thing of anger. They're focused on some government. That kind of action, even if it's for a cause that like maybe you're sympathetic to, which is like police brutality, it wouldn't change it.
I would say the Seattle protests where they were going after the federal courthouse.
Sure. Yes, if you're literally going towards like burning down the courthouses in your jurisdiction.
Well, careful, don't be too. It doesn't have to be burning down because nobody burned anything down for January 6th. It could be literally a sit-in in a courthouse to prevent a vote or something. No,
or just vandalizing the courthouse repeatedly.
No. Okay, so now you're dealing with. So everything is going to be, there's some level. There's never going to be able to finally define what anything is, right? For insurrection, for sedition, all that stuff. There are certain things that I think the authors of the paper say are sure shipwrecks, where you know that for whatever the outer limits of insurrection is, this is an insurrection. So there's going to be some cases where reasonable minds can disagree. I don't think reasonable minds can disagree about January 6th. I don't think reasonable minds can disagree about whether it's an insurrection. No, I don't.
Yeah, no.
I agree.
Well, wait. Hold on. I think real quick. I think reasonable minds can disagree about who was participating in the insurrection.
Correct. Yes.
Right.
No. 100%.
Because one of the problems was because I don't know that one guy in New Mexico. He wasn't a Proud Boy, was he?
No.
He was just a guy that was convicted there of trespassing. He didn't get it. Right. So it sounds like every single person who was at January 6th. It sounds like based on what New Mexico ruled. Every single person that caught any conviction whatsoever could theoretically be disbarred from ever holding public office again.
The grandma standing in the lobby.
Correct. Yes.
If you could prove that anybody this is what I would say so far as my idea. I wouldn't necessarily say Nick Fuentes because insurrection and rebellion. Oh, that's an interesting. That's a more. This is the thorny part of.
Because he was there.
Comfort.
He wasn't just there. He was encouraging people to break in, right? Yeah.
Hang on a second. So this is the thorny part and how it might sort of interact with the First Amendment. Remember, the Fourth Amendment is later in time than the First Amendment. If Nick Fuentes was literally telling people, "Go onto the Capitol, break in, go right now,"
which I think he was, by the way.
If he was doing that, that probably wouldn't even be protected by the First Amendment, right?
No.
That's why Nick Fuentes is a federal informant, and that's why he didn't get any charges. He's absolutely a fucking federal informant, but yeah, go ahead.
Yeah, so like, if he was directly inciting people to enter, then it wouldn't even be protected by the First Amendment, and so there wouldn't even be a conflict with the First Amendment. And so I would think, if Kamala Harris were like telling people, charge, go into the Capitol, I think all of us would agree they're giving aid or comfort. I mean, you would have criminal liability. If you tell someone, go burn something down, you can be an accessory to that crime just by encouraging them to do it.
Yeah, that would be
never been protected by the First
definition.
Amendment.
Like, that's the whole point. Yeah.
Yeah. So like but now the important thing is the motivation behind individuals. For people who are in the Capitol without the insurrectionist or rebellious intent, or without trying to support those efforts, I would say they, in my opinion, they should not be covered by Section 3. But if anyone who trespassed and was present in the actual Capitol grounds who had an intent to stop the steal or to, by their presence, intimidate or to be part of that insurrectionist uprising, I think would be covered by Section 3.
You know, you can find it to distinguish that difference. It's through criminal
because that's
trial.
really scary. Because we're essentially saying almost that anybody at January 6th that caught a charge could theoretically be disbarred from ever even running for public office in the United States.
If they're previous oath takers, so just keep in mind.
Oh, okay,
they have to be previous oath takers. Hang on, that's a huge limitation. There are a lot of people who are not previous oath takers.
Sure, but anybody there, for instance, that was a police officer is fucked, right?
Not necessarily. There's some question about whether police officers...
the gaggle of the old women that were there, that they were just kind of palling around, like
talking with security.
Yeah, like they're
the idea of doing it's undisputable that they were trying to overthrow. I'm like, that seems ridiculous to me.
They're grandmas.
But let's talk about like the shaman, right? That shaman.
Yes, shaman.
Even agreed, right? Covered by Section 3. If anyone is, that shaman is.
He was given the one thing it's weird is why was he being given like a tour? Like, because he was with security guards and they were walking him around. If they all thought, my God, he's here to overthrow the government. Why aren't they acting like it? If you're saying it's undisputable.
Well, hold on. My understanding was wait. My understanding is that like they did not have the manpower to actually deal with the amount of people that were coming in that day.
They were just keeping an eye on people for the Secret Service and the HRT response teams. Because what they were really afraid of is Pence and some of the other people down in the below. So they were having the guards just follow people around, basically, to give them eyes and ears.
So if you want to walk around and chat and do dumb shit or whatever for a while, that's highly preferable to just letting them loose in the building to see what they do.
Or letting them go unabated or unnoticed until they get to wherever Pence and the upper echelon of the presidential succession line was.
What do they call it in the Purge? They're level 5 people. They're not to be disturbed.
The level 10 people or whatever.
Unlike those normies who just be everything is destroyed, and we're just go fuck ourselves. Yeah.
I have to go on a little bit, but I want to deal with the big man. Let's deal with Trump. Why do I think that he gave aid or comfort? Because that's been like the big question, right? He hasn't been charged with insurrection. He hasn't been charged with incitement, and so this is the difficult question, right? Or some say it's difficult, which I don't think it's very difficult. So how can I
tagged with espionage? He's done anyway. So,
well, that's just silly. I don't think he should not. Wait, is that Esports Batman just said that?
Yeah.
You think that he should face Section 3 for the classified documents case, which had nothing to do with any of this shit?
If he's caught passing those documents off to foreign countries, yes.
Oh no, but that's not what we're talking about. So suppose he just wanted it for his collection.
Then no. But if it is shown that if he gets found guilty on the espionage charges, yeah, technically I'd give it to.
That's so silly.
I know. I understand you don't agree with it, but I'm telling you that's my thought process.
So you're saying if Donald Trump gets convicted of
hold on, wait, why is that?
Case, you think he engaged in insurrection or rebellion under the 14th Amendment?
Remember, I sat there and said espionage sedition.
That's a horrible point.
Or no, I'm sorry, espionage is the exception. You're right, correct. My bad. If he was counted as giving it off to other countries, then yes, because that is providing aid or comfort to treason. Yep.
Yeah. So he's being consistent at least, Pisco. I mean, he's not.
Okay.
Yeah. Let me put it this way: if it comes out that he was giving those documents over to people from Saudi Arabia or whatever, yeah, absolutely, he's disqualified under
Wait,
Section
really?
3. Yeah.
So so Hillary Clinton could have caught an espionage charge for
absolutely. It was that bad. Yeah, that's why I always maintain that Hillary Clinton was so fucking stupid that she deserved to lose because of the way that she handled herself.
No, sorry, not deserved to lose. Deserved to be disqualified for insurrection or rebellion or given aid or comfort.
No.
Wait. Can you explain why that's so ridiculous? Like, if you're literally if it was the case that she was literally passing stuff off to enemies.
She wasn't.
No. If she was grossly negligent in the sense of the statute.
There's a different no. So if there's difference. Remember, because espionage is not covered. Specifically, I don't cover espionage for disqualification purposes in my universe. So, her engaging in things that would be, negligent to the level of espionage that you would find would not necessarily disqualify her. But let's say, for instance, the email server was making copies and forwarding copies to a foreign country. That would absolutely, in that case,
what if it was forwarded to like Great Britain? Not would that be treason? They're an ally.
The deepest level of treason. They're their original enemies.
Not only that, but they're not the United States. Like that was the Jonathan Pollard case.
I think that's silly.
Just hold on, because you sat there and said allies, right? That was the Jonathan Pollard case that I was referring to, where the guy was giving sub-secrets to Israel, saying, "I believe in good faith that Israel, under the terms of our military alliance and agreement, are entitled to these documents and into this information." He was still tried for espionage, and he was still imprisoned for it, regardless of his intent. The point is, treason. Like, not treason, no, because it wasn't to make war against the United States or provide its enemies aid or comfort. He was doing it under a good faith belief that our military alliance and arrangement and the defensive agreements that we were under required them to have access to this. Whether or not,
but he's disqualified if he's a previous oath taker. He's disqualified.
Yeah, but like if he were giving it to Iran, for instance, yeah, he'd be disqualified. Same thing.
Okay, all right. So dealing with Trump, these are the actions that I think show that he gave aid or comfort. One is, I think that all the buildup to January 6th, where he's spreading and fomenting these lies, bringing the crowd to January 6th, being the moral and sort of practical progenitor of this movement, being the match that's lighting the sort of fire here. His statements on the ellipse, importantly, his statements of moral support to the insurrectionists while the insurrection was ongoing. And this, to me, is the clincher that was like, okay, I'm 100% convinced. I thought that, I thought long and hard about this. Usually, American law does not give affirmative duties of care to individuals. Like, if you see some baby on the middle of the street, right, and you have no obligation to go and save the baby, and you can watch it be run over by a car, and you're not liable for the murder of that baby. However, if you are someone who has assumed responsibility, right, and you are, let's say that you're a parent or you're a babysitter or you've contracted to take care of that baby and you just let it walk out, there can be consequences for you. In the case of Donald Trump, where the cost to him was so low of quelling the insurrection, when I said he could have used a button to stop the insurrection, he could have tweeted, "Get out of the Congress right now," and they would have, and they would have. And he swore an oath to uphold and protect the Constitution. For him to sit idly by and to not use that power that was imminently at his disposal to quell the insurrection in a second with no cost, no risk whatsoever to him.
You've gone over this. I feel like the facts of that are not 100% accurate, but maybe you don't care as much.
I think they're 100% accurate. Yeah.
I don't think anybody. I don't think. Okay, sure, but to be clear, for the statements of the DC Police, the National Guard, I don't think a single person is on record. I could be wrong. I don't think a single person is on record saying like we needed Trump to make this call. Like I don't think anybody. Even when they did act, I don't think they were. Yeah, but
hang on a second. Do we or don't we think that Trump could have, if he wanted to quell this insurrection?
I think he could have tweeted to help it, but I don't know if he could have mobilized military forces. Okay. I'm not sure.
No.
Well, that's not what I'm saying. No. I don't think people would have listened at that point, to be honest.
No, but they did listen when he did it.
No, they didn't. No, they I think they listened when the Capitol Guard showed up in force and started beating people up and shooting people.
Yeah. Wait, are you telling me that if Donald Trump went on TV and said, "I need you to stop right now. I need you to leave," and he tweeted something to that effect as well, you don't think that his supporters, the people there carrying his banners,
I don't think so. No, I think they would have said that he was pressured to do it, or that it's being.
Yeah, like what happened with the vaccine.
And you're also assuming that they would have seen it too.
But you're saying he should have tried.
I totally disagree. I do think he should have tried to
work, but you think he had an obligation. In the same sense, the babysitter might not be able to save the baby.
I think it would have
all the
absolutely
J6ers
worked.
had TVs ready to go just to hear his.
They had phones. They were streaming.
Do you think that there's even a chance that it would work?
I think it might have helped a little bit, but it was a riot. Like shit was fucked at that point, right?
Yeah, I think the majority, for like the little old ladies that were just walking around and oohing and eyeing, yeah, it would have done something. For the people that were downstairs trying to get to Pence and the Senate and the House reps that were in the basement with Secret Service, no, it wouldn't have stopped.
My perception is they were following Trump's orders. Even if you don't agree with me on that, and I can say that there can be people that don't agree with me on that. He did not mobilize the DC National Guard, which is the DC National Guard is under his command to mobilize if he wants to. It's usually given, I believe, to the Secretary of Defense. There's some interlocking authorities here between the Secretary of Defense and the President over who has command over the National Guard of DC. Yeah. Did not do anything to help them to do that. Those actions, those simple actions, those costless actions that he could have taken and didn't take, I think absolutely qualify with an affirmative duty, given the fact that he is the executor of our laws. The fact that he didn't take those costless, painless actions, I think is giving aid or comfort. And the way that I rationalize it is imagine that the garrison commander in Fort Sumter didn't take those actions, didn't try to take those costless, in my opinion, actions to quell the insurrection. What would have the framers of the 14th Amendment thought of his inaction in those circumstances? And I think it would have been an easy case for them to be like, and especially if the garrison commander was like sympathetic to the Confederates who were attacking Fort Sumter. You can imagine that situation. Everyone, I think, would have acknowledged at the time that would give an aid or comfort to the insurrectionists. And so that's kind of, I think, the structure of my case. The buildup and then the inaction with the affirmative duty, I think, is an easy case for giving aid or comfort.
I mean, I can see the argument, but I agree that it was an insurrection. I agree that, it should disqualify him. I just think they should have charged him with it, and unfortunately they didn't. And I think that's the limiting factor on their part. So this is kind of a monster of their own creation, to be honest, as far as I'm concerned.
We'll see, I guess. Well, thanks everyone for chatting.
Yeah, good job, guys. Wow, really knocked it out of the park today.
I wasn't intending it to be a big. I was just trying to shit talk Steven a little bit because I think he goes hard on me. I got in here.
I just came in here for the 5-minute interjection on the Arizona portion, and
damn.
Yeah.
Well, good job. Good job to all you guys. Yeah, nice work today, guys.
All right, take it easy.
I love y'all.
Do you agree with me?
Who?
With me.
About what?
Section 3.
Is Pisco right? Do you want to just say he pissed all over?
We'll resolve it in a future conversation.
Wait. I just want to be so that you're on the record. Do you think that January 6th was an insurrection?
I do, but that's not what any of my questions are about, I guess. Yeah.
Oh yeah, that's okay. Okay.
Yeah, but I mean, obviously, I think. Well, I don't. It just depends on what you're like. The people, the Proud Boys there were absolutely involved in organizing the insurrection. But I think it seems like the majority of the people there, I don't know if I would consider them insurrectionists. I'm not sure. I don't know.
But was there an insurrection on January 6th?
Yeah, or at least an attempt. Yeah, of course.
Okay.
But it was done by a very small percentage of people. Sorry, go ahead.
Do you think Trump gave aid or comfort to insurrectionists?
It feels like it. I think I could be argued out of it, but yeah, I'd lean towards yes. Yeah.
All right. Much love to everyone, and have a great day.
Love you.